मैं pattern to make a mention by Lord. One regularization of service. Risk my Lord, 2019 matter.
During bail my Lord, petition completed more than 10 years. Younger brother right leg was amputed my petition younger brother right leg was amputed my Lord. Yeah, fine.
Please give it to come next week.
Pardon my Lord. One WM press 2021.
Well, it's a fresh matter under Surfacy Act. The bank is moving. Obliged for this. Let the 2 matter land acquisition matter, 2022. After notice matter.
Your Lordship, this is a matter relating to OGLS Act. We have filed an appeal. However, the matter could not be taken up. And since, my Lord, there is a general eviction and demolition drive, my Lord, we pray to lease this matter. We have prayed for an interim order till the matter is taken up in the appellate authority.
Why are you not making such prayer before the appellate authority?
No, appellate authority is not functioning, Your Lordship. We have filed it in time.
Give it. See that.
My Lord, may I pray let it come tomorrow, my Lord?
Not tomorrow. Tomorrow is there, so it will come on 27.
My Lord.
Yes.
Supplementary list, item number 1.
Instruction. What's the instruction? Yes, I have the instruction. That instruction has come.
We are disposing of water.
The last line of the instruction. The last night notification has come up, but the last line is important.
What is this?
The last paragraph, last but one paragraph, last line. The matter will be placed in the court of RDC Cuttack soon after joining of the RDC.
No, tomorrow.
Yes. No, he is joining tomorrow, sir. But notification was, I'm assuming.
No, it's all.
No, notification is all.
That is, we accept.
Whether he is joining tomorrow or
Tomorrow,
that is what.
That exactly even. So I'll just pray one thing. I know the government but appointment has to be made. Somebody has to come. He will come and join. It takes 10 days of the plan.
Yes, they immediately join.
I think it has been done. So we are just disposing of in view of this.
Dispose of with
yes.
Let an interim order your worship pass till he takes over the
order is already there.
He is already there.
So that order he is not obeying. But I'll go on filing violations. But no point, Marat.
No.
Your worship's order will be confined till the RDC joins.
RDC is not a party hearing.
No, not necessary. This is a statutory authority order.
All right, you take down the order.
RDC should not be made a party.
On 21/8/2024, the submission was made by Mr. S.P. Misral and Senior Advocate that no one has been posted as Revenue Divisional Commissioner Central Division Cuttack to consider the interim application filed by the petitioner for implementing the status quo order dated 22/3/2024 passed by the RDC. Additional government advocate sought for some time to ascertain whether any competent authority is available to deal with the application under annexure Accordingly, the matter is listed today, and Mr. Janmejay Katkia, and additional government advocate, has produced the letter of the secretary dated 21/8/2024, wherein it is mentioned that the matter will be placed in the court of RDC (CD) Cuttack soon after joining of RDC. And he has stated that
Notification has already.
filed that notification.
Second page at the bottom. Second page at the bottom.
Second page.
CB permission.
Second page.
Yes, at the bottom.
Bottom means this B Parameshwar.
Yes.
And he has produced the notification of the Government of Orissa General Administration and Public Grievances 21/8/2024, wherein it is mentioned that Mr. P. Parameshwaran, IS Commissioner Consolidation Bhubaneswar, has been appointed as Revenue Divisional Commissioner, Central Division, Cuttack. Since the appropriate authority will now start functioning to deal with the application under Annex 13, the writ petition is disposed of, and it is expected that RDC should take off Annex 13 for consideration in accordance with law as soon as he assumes charge.
No, that interim protection, Nara. With due respect, Nara.
The interim order is there is no.
That order is status quo. If Lordship looks at, I have implemented, now the construction is going on with the help of opposite party number 2.
So the order is already there and it has not been vacated. So why are you becoming apprehensive?
OP number 3. Sir, it is rapidly going on with due respect, Nara. 200 to 300 persons are working day and night.
We are saying in this way that the Mr. S.P. Misral and Senior Advocate submits that the interim order which has been passed on
Sir, by C.
By C.
22
March 2024.
the status quo which was passed on 22/3/2024 may be permitted, maybe directed to the
OP number 3 to certificate.
the order the order dated 26 wants to status quo order be implemented in the letter and spirit till the matter is taken up by the RDC. All right.
Really good to word it. My anxiety is there to just approach your Lordship. Sir, no further construction.
No, we
Sir,
do not know. We are not. You see, we are not sure that whether actually in that particular plot you have no doubt you have given pictures,
given the photograph identity and everything.
But we are not sure that whether in that particular plot the construction work is going on or it is in and around.
File the affidavit to that effect.
It's all right, but it is to be adjudicated. If there is any delay after his joining, so you are.
But can you Lordship indicate within 10 days?
Yes.
Within 10 days.
No. As soon as he assumes.
As soon as he assumes charges, he will take up this. That is the order passed today. As soon as he assumes the charge, this annexure 13 will be taken into for consideration. Yeah.
The Lordship is not expressing any opinion.
No. We are not expressing any. Last time, we are not expressing any
So
opinion.
this year, not a lot of
Item number 2.
Yes, item
There
number
is
2.
one item, if you would permit me,
Yeah.
46, today's list.
List of it. Yes. 46, that is WPC number 5.
My friend is there for petitioner.
Yeah.
And today, actually, I came for this case only because of my personal difficulty. But still, fix it to tomorrow or any other day.
So tomorrow there is any date next week.
Next
As
week,
per
that's
your-
ready.
Acha. Then second September. Any interim order is there?
The entry model.
All right. You are supposed to appear for the
Bank,
Right.
State Bank
Bank,
of India.
Mr. Umakant Mahathir and senior advocate is present for the petitioner. Mr. S.P. Misral and senior advocate appears from the bank, and 6th that the matter will be taken up a week after, to which Mr. Mahathir has no objection. Accordingly, this matter will be commencing from 2nd September 2020. Interim order to continue. Yeah.
এইটা এই নন্দকিশোর দলিত petition.
Which one that is good of paper? Another item is there. then supplemental.
Item 2,
My lord, in this case, annexure 1 is a demolition notice has been issued and which is under challenge, my lord. Without going for a re-evaluation of the structure and the building, they are going to demolish. I have also represented, and annexure 2, kindly have a glance. In annexure 2, decisions to give the all benefit under the RR policy. But kindly have a glance to page 15.
No, yes, they have decided, and so you have not been paid.
We have not been paid
You expect to receive something more.
more.
For
For
that,
that reason, we have already represented.
for that there is other forums available. So why will pass that order?
Other forum is not
Ultimately, if
approved,
there is any structure according to you,
yes,
those are likely to be demolished. And if you are interested that the cost which has been assessed
yes,
by the authority
yes,
is at a leisure, so
is
for
less
higher
than
compensation, you can approach the authority. Why?
authority. I have already approved.
So
Yes.
approach them.
Annexure 3,
Why have you
Representation-
filed the writ petition?
repetition.
Representation is to be disposed of.
Unless it
So
will
this
be reassessed.
representation is to
Yes.
be disposed of.
Unless it will
All right.
be reassessed.
Which is that representation?
Representation annexure 3.
Annexure 3
3
series.
District.
Yes, my
Before whom it is pending?
lord. Collector.
District just
to
district collector Sundargarh. DMC.
Sundargarh.
Okay. Who is the opposite party number?
Opposite party number, my lord.
Is it number
Number
2? Okay.
My
Number-
lord, in this case, they have
Number
not
2.
implemented the annexure 2.
We are just passing the order that is to consider and dispose of the representation, because you have alternative remedy and you have already availed this.
Yes. Yes.
My lord,
So, condition under one, so it is to be disposed of. Yes.
my lord, till then, my lord, no coercive action.
No,
What
what
Coercive
course?
action. It is likely to be demolished. Only thing is that what
Compensation
amount you
is-
are to receive. If they have
Ne-
assessed at a lesser one, then you have to file it. You have
another-
already filed,
expert
and that is to
opinion,
be just.
with the pretty concerned, my lord, he has taken NTPC, who has taken the acquisition of the land. He has
You see, what would be its cost, and that cannot be assessed by us.
my
This
lord, that
competent
can be,
authority is there.
that can
No, that is also your prayer. উচিত
Prayer.
মূল্য প্রদান করা যায় বলি।
উচিত
Yes.
ଦେବେ ତାଙ୍କୁ।
till then, my lord,
Why?
Then କାହିଁ କଣ? ଆପଣ ଜମି ଆକ୍ୱାର ହେଇସାରିଲାଣି, ସେମାନେ ପାର୍ଟ କମ୍ପେନସେସନ ଦେଇ ସାରିଲେଣି।
the part compensation they have not paid.
Not to you.
Not paid, and already they have not
You
implemented
have to
the
receive it.
annexure 2, kindly have a glance.
All right.
Annexure 2 is of 2023.
23.
And then
Till
what you were doing for all
till
these
they
years?
have not implemented. My lord, after implementation of the annexure 2, they can go for demolition or revaluation, everything else.
So we have that made a representation.
We have made a representation. Kindly have a to annexure 2.
Alright.
Annexure 2 till today they have not implemented.
Sorry. Yes. Next year.
My as regard to annexure 2, my lord, kindly have some lines. Lordship, take
Your
it.
prayer is to dispose of. We are directing to dispose of. That's all. Yes.
Representation, my lord.
Yes.
My lord, communicate to me.
The moment you produce, that is the usual order. Certified copies to be produced before the authority. From that day, the time limit, that period, they are to consider and dispose of and communicate the order to you within this particular. All these things are there. Usual orders are to be passed. Yes.
Weekly list passover item number 25.
May I please?
25.
That matter
Yes.
challenging the.
Why you have kept it to today? There is some discussion on that.
Yes,
day.
sir.
So what was that discussion?
The,
Some query we made to you and
Yes,
you
sir.
said took time.
that the she rejected that the petitioner has been constructed the house, their house on
In a right.
Yes.
Question is that that land over which that construction, it's a government land. So you have encroached upon the land.
Yes, sir.
So question is that once a person has encroached upon a government land and constructed something, he has to definitely get those benefits. This other benefits, this about
Rehabilitation assistance.
rehabilitation assistance.
They have
That-
already
that is to be
considered.
provided to a person who is in unauthorized occupation of a government land and constructed a house, let us say.
Yes,
So where is that? We just wanted to know
Yes.
that policy also covers those persons also.
And yes, your lords.
अरे देखो ना
Because,
तो
yes, may submit, your lords. Because the authority has already considered my case, but petition also before your lordship.
ରିଲିଫ ଆଉ ଏ ରିଲିଫ ଟା ଭିତରେ କିଛି
ନାଇଁ,
ପାର୍ଥକ୍ୟ
ଏ
ଅଛି
ରିଲିଫ
ନା
ଅଛି,
ନାଇଁ?
ଏ ରିଲିଫ ଟା ପାଇଁ ସେମାନେ
ସେଟା ଯଦି ଅଛି ତ ଦେଖେଇବେ ଆମକୁ ପଲିସି, ସେଇଥିପାଇଁ ଆମେ କହୁଛୁ।
Annexer 6 series running page 26, your lords.
What relief they have already granted to you and what more you require. And
Yes, yes.
if that more is legally permissible in view of the policy, then certainly you are entitled. Okay, you are in a position that you are not disputing
Yes.
that the which was under your occupation was a government land and you have unauthorizedly constructed a house and residing there. So that
Prior to the notification.
prior. So that has been taken away. You have been paid compensation. Question is that other things which you are claiming, whether in view of that policy you are entitled to get it or not. That's the limited.
What is that policy? Don't show the list. List the persons who have been appended in the list might have been given this benefit,
Your lords,
but under what policy?
This list is very
List is so
because
policy.
Show us the policy.
You see, suppose something wrong has been committed. Let us say out of 40, 2 or 3 has been given, rest have not been given.
11 numbers of have been given.
Maybe. So why, let us say that is a illegal decision. So you do into say that we will also committed another similar thing, which is not there in the policy.
Petitioner grievance before your lords, only this list your lords. List semana consider kale je amaku more than 75. Seita hochi.
Where is that?
On annexer 6 your lords.
Annexer 6 is a list. You are not able to understand.
You are trying to avoid on that day. That is why we asked you to show us the list that in a situation in which you are placed, you are entitled to get that relief.
Yes, sir.
ସେଥିପାଇଁ ଆସିଲେ ଆପଣ ସେଇ ଲିଷ୍ଟ ଟାକୁ ସେଦିନ ଦେଖଉଥିଲେ, ଆଜି ବି ଦେଖଉଛନ୍ତି ଯେ କିଛି ଲୋକ ପାଇଛନ୍ତି। ଆମେ ସେ କିଛି ଲୋକ ଭିତରୁ କେମିତି ଜାଣିବୁ ଯେ ସେମାନେ ଆପଣଙ୍କ ପୋଜିସନ ରେ ଅଛନ୍ତି, ସେମାନେ ଏମିତି ଅନଅଥରାଇଜଡଲି ରହିଥିଲେ, ଏମିତି କନଫ୍ୟୁଜନ କରିଥିଲେ, କେମିତି ଜାଣିବୁ? ତ ପଲିସିଟା ଦଉନାହାନ୍ତି କାହିଁ ସାର୍?
ଦଉଛି ଆଉ ଗୋଟେ ଭିଲେଜ ର ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଲ୍ୟାଣ୍ଡ ଥିଲେ ମଧ୍ୟ ସେମାନେ ଦେଇଛନ୍ତି displace କରିଛି।
ସେ list ଟାକୁ ଆପଣ
list
ରଖିଲେ।
ଆପଣ produce କରୁଛନ୍ତି।
Basing on what policy? If at all the authority have extended the benefit to these people, if on the basis of a wrong assertion, why should we agree? Merely because these people have
On
what?
the basis
Should
of
you get?
2006 policy or
All right, where is that? Find out where is that clause. Show it. Show the clause. That's all. We have been insisting on that, which these people have been given the benefit, and you are also entitled to that. You find out that clause. Which one is that clause?
policy or
Which one is that clause which enables you to get this benefit?
Claim of parity ର principle ହଉଛି ଯଦି legally ଯୋଉମାନେ entitled ଅଛନ୍ତି ସେମାନେ ଯଦି କିଛି ପାଇଛନ୍ତି ଆପଣ ଯଦି deprive ହେଇଛନ୍ତି ତାହେଲେ you can, but somebody has get something, suppose let us say in an illegal way or irregular manner ତାକୁ ଦେଇଛନ୍ତି ତା ସାଙ୍ଗରେ ଆପଣ claim of parity ଆପଣ କରିପାରିବେନି, that is the fundamental thing. ଓକେ, ତେଣୁ ସେମାନଙ୍କୁ ଆମେ ଆପଣଙ୍କୁ ଦେଖିବାକୁ ହେଲେ ଯେ ସେମାନେ ମଧ୍ୟ ଆପଣଙ୍କର list ରେ ନାଁ ଅଛି।
list 40 out of 40 numbers of paid in the as like displaced persons ଆମକୁ ସେମାନେ more than 75% ଉପରେ consider କରୁଛନ୍ତି।
displaced person ଆଉ displaced person in an
Unauthorized.
unauthorized place of government land ରେ construction କରି ତା ଭିତରେ ପାର୍ଥକ୍ୟ ଅଛି ନା ନାହିଁ? ଆପଣଙ୍କର ସେଠି ନିଜ ଜମି ଉପରେ ଘର କରି ରହିଛନ୍ତି, ସେ ଲୋକର ଯାହା ଫୁଟିଂ ହବ ଯେ ଗୋଟେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଲ୍ୟାଣ୍ଡ କୁ ଏନକ୍ରୋଚ କରି କନଷ୍ଟ୍ରକ୍ସନ କରି ରହିଛି ସେ ଦି ଜଣଙ୍କ ଫୁଟିଂ ସେମ୍ କି? ଯଦି ସେମ୍ ଏଟା କୋଉ ବେସିସ୍ ରେ ଆପଣ କହୁଛନ୍ତି?
That is one part. See, that is one part. The other part, Mr. Behra, is that according to you, these people are also in the same footing as that of the present petitioner.
Yes.
According to you, we agree with that, provided the policy is to that effect. Merely because their name appears and they have been given benefit, we cannot give you that parity. That is what my Lord is saying. So try to understand which policy gives you this benefit. You are entitled to this benefit. Show it to us.
The
Which particular provision of that policy?
the special law has rejected the case of the petitioner on the ground that the petitioner
Answer the question, sir.
there is no provision. There is no
And
provision
then-
in 2006
and-
policy.
Then
There is no such provision, Your Lordship.
So
that is the exact
I think these people have been included and the benefit have been given, and you also claim the parity. How could it be? So a mistake if has been committed, should it be perpetuated by this court? How can it be?
That the,
The apology specifically see Annex 8, which has been sought to be quashed at page 42.
no, you place
The order effect has not been produced. Here, this is in the communication to the Advocate General Office, the complaint letter.
Does not
no,
that
the
is- that is-
43 ରେ ଯୋଉ reason ଟା ଦେଇଛନ୍ତି ସେମାନେ ସେ place କରିଥିଲେ. It's come to page 43.
Yes, boss. That I have gone through. But
That is
the
what-
communication to the Advocate General in the content of one complaints affidavit. So real order has not been produced.
It's all right, but thing is that this is the particular reason has been so if that is the reason, the question is that what is the policy and whether the persons who have got the benefit they stand on the similar footing or not. That is the thing. Unless the policy allows merely because somebody has been given something out of some consideration or whatever it may be, that is not a to claim parity. So,
9 of the
So-
policy, Your Lordship.
Mr. Behra, let us be clear. In page number 43, in the first paragraph, whatever has been mentioned by the special LA, that is factually correct. That there is no policy in which it gives entitlement to a person to get the RR benefits if he is unauthorizedly encroached over a government land and constructed something.
That is, as has been stated by the not any mention in the RR policy, Your Lordship.
Yes.
Instead of
That is what
paragraph
is-
9 of the RR policy, may I read, Your Lordship? That the benefit to the landless or homesteadless encroachers common to all categories.
कौन है लाभ?
What is that?
that the petitioner should have been displaced, considered as a displaced family. An encroacher family who is landless as defined in the Odisha Prevention Land Encroachment Act 1970.
No, no, keep that. No, keep it. Which is that page? Page number?
197, yours. RR Policy 2006.
No, just read that benefit of that. Just read that.
An encroacher who is landless as defined in the Odisha Prevention of Land Encroachment and is in possession of the encroached land at least for a period of 10 years, continuously prior to the date of notification under relevant laws, declaring it intention will get ex gratia equal to compensation additional under the Land Acquisition Act 1894 for a similar category of land to the extent of land under his or her physical possession up to the maximum one
So
standard.
that three things you see from that particular paragraph which you placed, that he must have been in continuous possession for 10 years.
Yes, sir.
Right? Number one. Number two, he
Landless.
must be a landless person.
Yes, sir.
Two. And he would get here. So what you are claiming here for this petitioner?
Claiming before your lordship that petitioner case has been considered to get the RR policy, but decided that more than 70%, not a fully displaced family. This only grievance annexer 6 जो list अछि सेमाने list prepare कले more than 75% अनुसार, whereas the entire land, entire Imuja was submerged due to the construction of the Lower Indra irrigation project. So the petitioner should have been considered as a displaced family. Only these grievance before your lords. हमको 75% more than 75% consider न करा जाए कि हमको consider करा जाए displaced family हिसाब से. other similar village को जो माने government land थिले मते समान देई जंती RR policy displaced family हिसाब से list ता दो.
So Mr. Katkia, we are recording it that it is his submission that similarly situated persons have got the benefit. It is up to this one, so we consider and disclosure. It is let it
What a list those.
the petitioner has prayed for passing the letter number 590 dated 5/4/2024 of the special LA is opposite party number.
Yes. Opposite party number 4, 5 or 5.
Opposite party number 5, wherein the observation has been made that since the petitioner had constructed dwelling house unauthorizedly over enclosed government land, and there is no provision of extending RR benefits for the land losers having constructed dwelling house unauthorizedly over enclosed government under the Odisha RR policy 2006. Therefore, the claim of the petitioner to grant of RR assistance under the displaced family category does not arise and cannot be considered. It is the contention of the Land Council for the petitioner that there are number of persons who are similarly situated like the petitioner, who have got such benefit, and in support of such contention, he has annexed a list of the displaced families at Annexure 6 of the writ petition. Learned counsel for the petitioner also placed this is clause 9, clause 9 of the 2006 policy, which deals with benefit to landless and homesteadless encroachers common to all categories, without expressing any opinion on the prayer made. We dispose of the writ petition at the authorities, that is this, who is to consider your case, that is this OP number 5, once again.
One second.
OP number 5 to reconsider the prayer of the petitioner, taking into account the list which has been furnished before this court by Annexure 6. It is made clear and pass appropriate order within a period of 3 months from the date of production of the certified copy of the order, and communicate the order to the petitioner within 2 weeks taking the decision. It is made clear that we have not any opinion relating to the entitlement of the petitioner to get the benefits of RR policy. Disposed of further. Similarly, the other cases of
All other matters are similar. Highly operative.
Item 26.
CI criminal. Petitioner is a land user, my lords. Affected compensation, affected of family compensation not being paid. The petition challenging the order Annexure 6, my lord, page 26.
You are challenging what? Annexure 6?
Annexure 6, my lord, I am reading page 26, last paragraph. Much prior to this transaction, the people of this locality more or less aware.
You are reading page number 26.
26,
Annexure
last
6.
paragraph.
Last paragraph. Much prior, yes.
Much prior to this transaction, the people of this locality more or less were well aware about the commencement of Lower Shuktal irrigation project, and some of them have purchased small extent of land with intention to get undue rehabilitation assistance benefit. The petitioner is a outsider of village Kumiapalli. I reverse from copy of Aadhaar card and voter identity card submitted by him during process of hearing held on 17/5/2024. The petitioner is not dodging his livelihood in the village of Kumiapalli by acquisition of land 0.02 decimil of land which was purchased by him in the year 2010. The authorized survey agency MRT Global Survey LLP Noida UP therefore excluded the name of the petitioner in the socio-economic survey of village Kumiapalli under Lower Shuktal irrigation project. In such circumstances, the claim of the petitioner for inclusion of his name as affected family is rejected, as he is not lodging their livelihood by acquisition of the aforesaid area 0.02 decimil of land for he received compensation from the competent authority. Only he has received for the land value only. Affected compensation not be given.
That is to be given to which category of person?
It is the affected family. As per the section 3 of the section 3,
number page?
Page 29. Second 3 definition C, my lord, CI.
C or 3 tab?
My lord. CI.
0 Roman 1.
Which land or movable, other movable property has been acquired. The petitioner only land acquired by the opposite party. Petitioner come under this the definition of section 3C Roman I, my lord. as the affected family.
No, you mean to say that even if only 2 decimal of land
My lord,
has been acquired
my lord.
by the government, you will also come within the definition of 3C Roman 1.
Roman.
That is your content. So what they have stated.
That stated that matter here, so stated the petitioner is left.
You do one thing, you read previous paragraph of that very page, on page 26. From the copy of the ROR, you read that paragraph.
From the copy of ROR voter identity card and Aadhaar card filed by the petitioner on 17/5/2000 during hearing, it is ascertained that the petitioner namely S.K.Sahoo, son of late Sahoo, is the resident of village Khaksabal of P.R. Sautala in the district of Balangir. He has purchased 0.02 decimal of homestead land in village Kumiapalli, U.S. Losinga, district Balangir in the year 2010. And the land was mutated in the year 2013 by the mutation case number 845 of 2013 of Tahsil Losinga as holding number 106 by 429 of the Moja Kumiapalli. The petitioner purchased the land 2010 and the land acquisition proceeding was initiated in the 2021 manner. Kindly see annexure 2, the indication number 5/12 of 2022 up to 10 years.
Yeah, just a minute. So your date of purchase, as it appears, that was in the year 2010.
10 million.
And the mutated, it was made in 2013.
13.
So when that project started?
Well, project started, land acquisition proceeding was initiated against the petitioner 5/12/2022.
No, not a. I mean to say that what they have stated that some persons purchase the small extent of land to get the RR benefits after commencement of the that project. So we just want to know that when that lower Saktel irrigation
commencement in the year 2000 million.
2000.
2000.
So that is the exact reason why जे आपण जदि जानिले एठी गोटे एई प्रकार प्रोजेक्ट हबो ताले लोक कोन करूछन प्रोजेक्ट रे एमती हेले लैंड एक्वायर हबो ताले आरआर बेनिफिट गया पई सेठी गोटे जगाटी किनी दउछन तेणु सेमानकु कुहा जीवनी केवल जमीर जहा ये हबो सेटा दिया जी तो आरआर बेनिफिट्स रो से माने पाइबे नाही बिकॉज ऑफ आफ्टर दिस तेणु आपण जदि कहउछंती जे this project commenced in 2000, then this observation which has been made is quite correct that you are an outsider and because your Aadhaar card and voter identity card it indicates the riders, but you just purchased that land much after this notification that was made in 2000. You purchased that land in 2010.
Well, the petitioner village has not declared as 11-1 notification as per the 2013 Act.
No, jaha lekha aichi, you are an outsider, kono Kamiapalli or not.
Kumiapalli.
Right? So that is also the address which has been given by you in the writ petition. You are not a resident of that area earlier, right? So you just purchased 2 decimal of land, right? And that is the reason why they stated that you are an outsider and you just purchased in 2010 when from 2000 that project has already commenced and then you are not losing the livelihood in that particular village for acquisition of that land. So that is the Mr. Das, he comes under the affected family because the
part of the
land has been acquired and is, but so far as this RR benefits is concerned, is there anything in the policy that if after the commencement of the project, if somebody purchases a piece of land in that area, he is just only to receive that value of the land, but not the all other benefits which are available in RR policy. So
Let me verify.
that is to be verified. Have you examined this point?
My
There is a clarification under the prior policy. Somebody purchase prior to 3 years, they will get benefit.
second
That is the-
argument, second.
3 years prior to the
Ma-
acquisition.
Supreme Court also category has
3 years prior to the acquisition. 2004.
Acquisition started in
2000. Means in 1997 he should have purchased.
My lord,
89 policy, under 89 policy, there is also a clarification.
Hmm.
10 years, that is contract.
That was 10 years.
But 2006 policy,
3
3
years.
years. And Supreme Court also said that only gets
in 3
compensation.
3 years prior to the commencement of that.
Yes.
Notification.
No, notification is 2000.
For year only get only compensation.
That has been paid to him. Say what he is stated.
acquisition 2022. Land acquisition initiated 2022.
Land acquisition actually said that is not the main date is the date of notification. କାରଣଟା ହଉଛି ସେମାନେ ଯେ ନୋଟିଫିକେସନ ହବା ପରେ କିଛି ଲୋକ ଜାଣୁଛନ୍ତି ଏଇଟା ଆକ୍ୱାର ହବ, ତେଣୁ ତାଙ୍କ ଜମି ନେଲେ ଏଇ ବେନିଫିଟ ଟା ପାଇବେ, ତେଣୁ ଗୋଟେ ଛୋଟ ପିସ୍ ର ଲ୍ୟାଣ୍ଡ ସେଠି କିଣି ଦଉଛନ୍ତି। ସେଥିପାଇଁ ସେମାନେ ସେ ଜମିର ମୂଲ୍ୟ ପାଇବେ, ସବୁ ଠିକ ଅଛି, ବଟ ଏଇ ବେନିଫିଟ୍ସ ଗୁଡାକ ପାଇବେ।
ମାନେ Roman 2 ମାନେ next Roman 2. A family which does not own any land, members of such family may be agricultural developers, tenants, including any form of tenancy or holding of subscript rights, share corporate or artisan, or who may be working in the
Set out a case like
Yes,
this
sir.
in your repetition. Have you taken such argument?
But-
ନା ଏଇଟା ଅଛି ତେଣୁ ମତେ ଦିଆଯାଏ।
There are 3 years
You
prior.
have to take, Mr. Counsel, you have to take a specific ground that affected family ର definition ଭିତରେ ଏଇଆ ଆସୁଛି, ମୁଁ ଏଇ କ୍ଲଜ ଭିତରେ ଆସୁଛି, ତେଣୁ
ଏକ
ମତେ
ନମ୍ବର ଭିତରେ।
ଡିପ୍ରାଇଭ କରିବାର ଜଷ୍ଟିଫିକେସନ କିଛି ନାହିଁ ଏଇ ଗ୍ରାଉଣ୍ଡ ରେ ଯେ ମୁଁ ସେଇଟାକୁ 2000 ମସିହା ପରେ ନୋଟିଫିକେସନ ହେଲାର 10 ବର୍ଷ ପରେ କିଣିଛି ବୋଲି ମତେ there are so many 1 2 3 and it goes up to 6, ତେଣୁ ଆପଣ ମେକ୍ ଆଉଟ୍ କରିଛନ୍ତି ସେଭଳି କିଛି ପ୍ରିଡିଂସ୍ ନେଇଛନ୍ତି, ଆପଣଙ୍କର ଆଭରମେଣ୍ଟସ୍ ନେଇଛନ୍ତି ପିଟିସନରେ?
Section 11.
You are perhaps you are not following what you want. ଆପଣଙ୍କର ଷ୍ଟାଣ୍ଡ ହିଁ ସେଇଆ ଯଦି ନଥିବ, ଖାଲି ପ୍ରୋଭିଜନ ଦେଖେଇଲେ ଆପଣଙ୍କୁ ସେଇ କ୍ୟାଟାଗୋରୀ ଭିତରେ ଆସିବାକୁ ପଡିବ।
Kindly see chapter 4, 11 on page 39. Publication of preliminary notification of power of officer thereon.
30 Yes.
Section 11.
Hmm.
Publication of preliminary notification and power of officer thereupon. Kindly see subsection 4. No person shall make any transaction or cause any transaction of land specified in the preliminary notification or create any encumbrance of such land from the date of publication of such notification till such time as the proceeding under this chapter are completed. Well, after acquisition of the land, no sale and sold have the
Publication of the notification. No person shall make any transaction or cause any transaction of land specified in the preliminary notification. So preliminary notification ଆପଣ ନିଜେ ହିଁ କହୁଛନ୍ତି ଯେ 2000 ମସିହାରେ ହେଇଛି।
No, 11-1 notification year 2022.
No, 11 is a LA proceeding. Land acquisition seটা proceeding ହେଇଗଲାଣି. Before that, all paraphernalias have been completed. Section 4, 6, all have been completed.
Some notification the issue
Right. Where is that?
next to guys
Next.
no.
ଏଇଟାକୁ ଟିକେ ascertain କରିଦିଅନ୍ତୁ, let him produce. So this matter will be commencing from 2nd September 2020 as prayed for by the Land Council for the petition to produce the notification, relevant notification. on the under section
11.
11 of the Acta Purana 2013 Acta Purana. Yes.
Item
My lord, the petitioner, his land was acquired, which is apparent from the Annexer 1, page 12. My lord, compensation was assessed, and my lord, against that, at Annexer 2, he approached the collector, who is the appropriate authority for enhancement of compensation. The lordship may take your lordship to page 18.
For recalculation of the compensation.
Recalculation in terms of the 2013 Act.
What happened? Your representation on Annexure 3.
No, I can case as is required, page 18. The lordship may kindly go to page 18. In the present case, as per 3G proceeding, the calculation has been made from Amukha, and date of award passed by CALA of Mauja Palasa is 22/2015, which attracts the Government of India instructions mentioned supra. In view of the above and law provision, the Special Land Acquisition Officer and competent authority is directed to recalculate compensation due to the petitioner as per new act, and differential amount, if any, be paid within a period of 6 weeks. That order was passed on 15 September 2021. My lord, 2021's order till today, my lord, they have not paid me the compensation. Only at page annexer. They have given me a notice in January 2024 that come and accept the compensation. I went there. For whatever reasons, my lord, they have not paid the compensation as of now, my lord, until today, though it was to be complied within 6 weeks. At a competent authority under the Land Acquisition Act, it is the OP number 3, my lord.
3.
My lord, the learned collector is the appropriate authority as the arbitrator for enhancement. He has passed an order.
No, now the money is to be disbursed by the Land Acquisition Officer.
My lord.
Him to come with the bank draft.
I have solved the copy.
Who is to?
NHI ର ଗୋଟେ panel ଅଛି. I have also solved the copy, my lord.
Ask him, we are reflecting his name in the cause list. Ask him to remain present on the next date. We are fixing it on Tuesday.
My lord. Okay.
Amitabh Das.
My lord.
The Land Council for the petitioner submitted that in spite of the order passed, the collector cutter bracket opposite party number 4.
Collector cutter is the competent authority appointed by the central government.
Yes, yes. As arbitrator for enhancement.
Arbitrator and collector cutter bracket opposite party number 3.
4.
Opposite party number 4. Directing the Special Land Acquisition Officer and competent authority, NS5 Khurda. That is opposite party number
3.
To recalculate.
To recalculate the amount of the compensation due to the petitioner as per the new act, and differential amount, if any, to be paid within a period of 6 weeks. This order dated is 15/9/2021. The petitioner has not been paid anything till date, and for that he has also filed representations. And he received a notice dated 29/1/2024 from card notice file.
Same OP number 3.
OP number 3 to receive the compensation amount of rupees 8,82,586 being remaining present on 5/2/2024. However, on a the petitioner remain present in the office of opposite party number 3. He has not paid anything, and till date he has also not received any compensation amount as per the order passed by the opposite party number 4. The land counsel for the petitioner further submits that Amitabh Das used to appear for the opposite party number 3, and he will serve a copy of the writ petition on Mr. Das in course of reading. With this matter on 27th of August 2024, indicating the name of Mr. Amitabh Das in the first item, in the first list, as well as in the top of the page. Yes.
Item 38.
Please come to the mic.
Let me fix a date for hearing.
No, the pleading is complete.
The rejoinder I have to file.
Rejoinder?
I have to file.
So,
in the meantime, I will file 10 days.
Okay. The learned counsel for the petitioner seeks for an adjournment to file. So let it come 23rd of September 2024. And in the meantime, rejoinder affidavit is going to be filed, serving a copy and the land counsel for the state. Okay. Yeah.
Item 39.
Maybe that one time
The land counsel for the petitioner seeks 1 week time to remove the defects as pointed out by the stamp reporter. Immediately after the defects are removed.
similar matter is pending.
No. First you remove the defects, then we'll ask the other matters to be tackled. Yes.
Okay.
Item 44.
Rule 44, my lords, on behalf of Mr. Inlanka, may be taken up next week.
You are making a petitioner.
Hello.
Niranjan Lenka.
Hello.
What do you want?
Let's maybe taken up next week.
It seems that counter has been filed by OP number 3 and 6 as per the noting.
I beg your pardon, my lord. On behalf of Mr. Sahoo, OP number 326, 3456. He is ill and he cannot.
No, it's all right. You have filed the counter affidavit. Petitioner's counsel seeks for an adjournment till next week. You want it next week or a week after?
We have received the counter on 19/7.
You want to file any rejoinder or that you say? The counter affidavit has been filed only by OP or any other?
Only 3
and 6. All right. The learned counsel for the petitioner submits that he has received the counter affidavit filed by opposite party number 3 and opposite party number 6, and he intends to file a rejoinder to the said counter affidavit, and the 1 week time may be granted. Put of this matter, give a date. Yes.
Obliged.
Item 45.
45, I'm a virtual word, and I have also filed a rejoinder. This is a matter.
May I just
Item 45
just one moment.
next week, my lord.
The last order.
Connected matter, yes. Connected matter, I have received the counter yesterday.
Connected matter means WPC number
67775/2020 and 2932. Sorry, 32414.
Okay.
That
so far as 6775 of 2020 is concerned, it is filed by one Kulamani Naik.
Yes, sir.
And there the counter has been filed by opposite party number 1, so also opposite party number 2 and 3.
2 and 3 I have counter filed by the 2 and 3. I have received the counter yesterday.
You are for petition.
I am for the petitioner. Kulamuni.
Right, but rejoinder has already been filed
Against that OP number 1.
Oh, I see.
So in that case also, I have read that counter, no rejoinder is required. So I have called the client on Sunday. Your lordship, keep it to next week only.
Yes, Mr. Mishra, any?
Minor 2 weeks retired. 2 weeks is required to file reply because they are the employees of the Deccan
Your item, the first item, Prahlad Jena.
Required because violation of the particular
Not
provision.
audible, there is some problem.
Am I audible, my lord?
No, it's not audible.
I said 2 weeks time, my lord. 2 weeks time. He is seeking for 2 weeks time. 2 weeks time. You are not audible, Mr. Mishra. You have to kindly loud your voice. Some glitch is there. Anyway, he is seeking for 2 years.
It's all right. WPC number 6775 of 2020. The Land Council for the petitioner submits that he has received the counter affidavit filed by the opposite party number 2 and 3 yesterday. And he intends to file.
No,
he may, after going through the same, he may decide whether he intends to file any rejoinder affidavit to the said counter or not. And the matter may be taken up next week. However, in the connected matter that is in WPC number 22717 of 2018, Mr. Kali Prashanna Misral and senior advocate seeks for an adjournment for 2 weeks. Mr. Gautam Kumar Acharya, land senior advocate, is present for the opposite party in all these 3 matters. That is so and so. On consensus of all these parties, put up this matter. We are taking up this on 9th of September 2024. It is 2 weeks will be over, and all of you are
Yes, ma'am, with us.
Put up this matter on 9th of September 2024. You decide whether to file any rejoinder or
yes. Interim order is there.
in which way?
In all cases.
In my 2 cases, interim order is there.
In my case, interim order is there.
6775 and 32414.
Just check for the interim order to continue till next date. And Mr. Mishra, in your case, is it there?
Instruction is interim order is there.
Okay.
Not to recover the amount.
All right. Interim order to continue till next date.
In the second matter, my lord, the rejoinder has been filed. Let a copy be solved on us also, my lord.
Which one?
The second matter, WPC 6775.
They have filed a copy of
Mr. Acharya is appearing for the
for the AG Odisha.
Has not been received by the Land and State Council.
I'll make arrangement for giving him a.
The Land Council for the state submits that the counter affidavit which has been filed by the Accountant General has not been served on him. Mr. Acharya submits that he will take steps in serving the counter affidavit on the State Council by next week. Okay, so matter.
And I also may be served with a copy of the rejoinder, my lord. A rejoinder has been filed by the petitioner in this case, I think.
What do you want, Mr.
In the second matter, this WPC 6775, a rejoinder has been filed by the petitioner. A copy may be served.
Rejoinder you have filed that.
Rejoinder filed by the petitioner has been served. The council was appearing then. Now he is appearing.
Yes, because the change of council.
Right. Let a copy of the second item, that is 6775 of 2020. Let the rejoinder filed by the petitioner to the counter filed by the opposite party number 1 be served on the Land Council appearing for OP number 1. Hello? So all these 3 matters will come on 9th September 2024. And interim orders in all these cases are to continue till next day.
Obliged.
Yes.
Item 47.
47.
I am for the opposite party. Mr. Mishra will argue the case. He has some difficulty today. Next week I will take it.
Mr. Rao, what do you say next week?
Yesterday, Mr. Mishra has talked to me.
Yes, talk to you. No, it is up to the we are asking him. It's an internal affair between you and Mr. Mishra. Submission is made, so we are taking up this matter.
Next week only.
Next week. Okay. Mention is of Mr. Mishra that he has got some personal difficulty and the matter may be taken up next week. Mr. Rao has no objection. Run counsel for the petitioner.
We commencing from 9th.
9 September.
We commencing from 9 September 2024. Yes.
Item 38.
9th.
Yes.
The challenges the order dated 20th August 2019 passed by the Law and Central Administrative Tribunal, Kotak Bench. And they dismissed the petition.
Opposite party.
Union of India Milan.
We are
appearing petition. Yes, we are appearing.
Mr. Party is there. Who are
Survey of India.
Survey of India. You are also appearing for.
And Geos.
Yes, we are Survey of India. We are
Mr.
appearing for
Party,
Survey
you are
of India.
appearing for
Of
this
the
2 and 3 also.
Yes.
Okay. Argue your case.
My lord, sole point is the other of the petitioner died, my lord. I have filed a dead chat, my lord.
What you are challenging first?
My lord, I am challenging the dismiss the petitioner's case for compensation appointment by the Law and
You are challenging the order passed by the Central Administrative Tribunal.
Mine.
Which is Annexure 3.
Annexure 3.
Okay, let us come to that. Let's see that.
Page 130, my lord. In this case, I am placing that, my lord. In this case, the applicant is the son of late M.M. Kundu, who was working as Khalasi under the respondent on 6/5/2010, leaving behind his wife, 4 daughters, and 1 son. The applicant applied for the compensation appointment on 5 January 2011. No decision on it was taken till 8/6/2016, Annexure A by 3. When it was informed to the applicant that since his case could not be accommodated for more than 5 years, even after adequate consideration, it has been rejected. The applicant, by this order, has been filed this way with a prayer for the following reliefs. To pass the order dated 8/6/2016 under Annexure A by 3, passed by the respondent number 2.
Okay, leave that. We come to the counter affidavit. What is there? Paragraph 3. Paragraph 3. Next page.
Paragraph 3. Counter has been filed opposing the way, stating that as per the guidelines, the applications for compensation appointment are to be considered as per the guidelines, and it is necessary.
It is not necessary.
It is not necessary that each and every case has to be considered. There is a restriction put on the number of posts which can be offered for compensation appointment. The respondent have justified the decision communicating by the order dated 8/6/2016 A by 3 by citing the following judgments.
Okay, leave that. Now you come to paragraph 5.
I have perused the impugned order and the pleadings of the parties in the impugned order dated 8/6/2016 A by 3, enclosing the order dated 25/5/2016, stated that the reason for rejecting the applicant's case was that his case was more than 5 years old, whether his case has to be duly considered by the respondents, and if so, how many times in the past it was considered, and the reasons for not applicant's case for compensatory appointment has not been mentioned in the order dated 8/6/2016 /2
2000
annexure A by 3.
Yes, next paragraph.
Next paragraph, as explained in the counter, the case of the applicant has been considered by the board of officers during 2012, proceeding at annexure R by 1 during 2013, the proceeding at annexure R by 3 during 2014, the proceeding annexure R by 4 during 2015, the proceeding annexure R by 5, and again during 2016 proceeding at annexure R by 6. It is in the counter that since the adequate consideration has been given to the applicant, the board of officer recommended that the case of the applicant might be closed. Nothing has been mentioned in the counter if the decision taken in respect of the applicant was communicated to the applicant with the reason for non-acceptance of this case as mentioned in the proceeding of the meeting of the board of officers.
Leave it. Next, you come to paragraph number 11. Yes.
It is the settled law that the compensation claimed as a matter of right, but every candidate was applied for appointment under the scheme is entitled for consideration of his/her case in accordance with the scheme and for being informed about the result of such consideration. In this case, the applicant's case has been considered by the board of officers during 2012, 2013, 2014, 2015, and 2016, and it was found to be as more deserving candidates were available for consideration. Such contentions in the counter have not been contradicted by the applicant. The judgment cited by the applicant in the way will not be helpful for the applicant's case since his case has been duly considered a number of times and it could not be accepted under the rule as more deserving candidates were available. None of the judgments cited by the applicant in the way has laid down the law under which the action of the respondent can be flouted. In view of the above, some of the view
So
that
what is your submission?
my lord, in submission, my lord, the petitioner's father died in 6/5/2010, applied in the 2011, and the board of directors in this office memorandum number 1/4/2013, my lord. The
It seems every year the board of officers were considering your case
in 2012
along with others.
my
And more
deserving
candidates were available. That is why for that particular year you are not giving.
my lord, your lordship
If
has
that way it just went on, and finally in 2016 also same thing happened. Then your case has been thrown down. So what is your submission?
my lord, your lordship come to the page, my lord, page 39 of the order, running page of my petition.
Yes.
Man, this letter, my lord, in 24th May 2016, which I have challenged in the OA, my lord. In my lord, lordship has a first paragraph and my lord, I am placing that first paragraph. On the above cited matter, is informed that the 83 cases of compensatory appointment were considered during the year 2016 by the constituted board of officers against 12 available vacancy under 5% quota in the light of Government of India instructions/guidelines issued and to achieve the objective of the scheme of the compensatory appointment and to ensure complete transparency and to decide merit of the case. All the applicants were assessed and allotted points on various parameters as mentioned below, suggested by the Government of India Ministry of Science and Technology, Department of Science and Technology, Office Memorandum Number SM.
Leave it.
1/4/2013. When the petitioner's father died in the 2010, that rule has not come. And secondly, I am the petition of 2011. Lordship just parameter to the
No, suppose this has not come, but at that point of time, there must be something for which you claim that you are to be extended the benefits of that compassionate appointment. So, ସେତେବେଳେ ଯୋଉ existence ଥିଲା ଯୋଉ policy, ସେତେବେଳେ ଆପଣଙ୍କ କେସ୍ କୁ ବି କନସିଡର କରାଗଲା ଏବଂ ଅନ୍ୟମାନଙ୍କ କେସ୍ ବି କନସିଡର କରାଗଲା ଏବଂ ଯେହେତୁ ଗୋଟେ ଲିମିଟେଡ ନମ୍ବର ଅଫ ଭ୍ୟାକାନ୍ସିଜ ଥିଲା ଏବଂ ଆପଣଙ୍କଠୁ ଅଧିକ ଡିଜର୍ଭିଂ କ୍ୟାଣ୍ଡିଡେଟ୍ସ ଥିଲେ ସେମାନଙ୍କୁ ପାଇଗଲା ଆପଣଙ୍କ ସେ ବର୍ଷ ପାଇଁ ତାପର ବର୍ଷ ଏଇ ରୁଲ୍ସ ଅନୁଯାୟୀ ଯୋଉଟା ଆସିଲା ସେ ଅନୁଯାୟୀ କରାଗଲା ଏବଂ each year it was found same thing happened. So what is the illegality committed by the
clearly, my lord, I am referring to the state rules, my lord, in 1990 rules and 2020 rules in Malayananda case at par with my lord, where it has been also defined that at the time of relevant death of the petitioner, that time rule prevailing, that will be considered.
Yes.
I pray, my lord, the petitioner's father died since 2010. At that time, my lord, the government 1/4/2013 5% quota has not been not in there, so that I am entitled to, my lord, in old case, my in at par with parameter to the.
No, what was the rule prevailing then?
Prevailing, my lord.
This restriction of 5% was not there according to you.
At the time of
How would you find out what is that? You stick to that. What is that?
Suppose it is not there. It came for the first time in 2013.
13.
But in 2010 you apply, na?
11.
11. So 11 or 12 बेलू जो थिला existing rule से rule अनुଯାयी आपन को case consider हेइनी बेली आपन को stand with.
And they have your lordships and they have stated, my lord, that 5% quota is not there.
Query that
Lordship may see the page
first of all
51.
show that rule what was there in 2012 11 when you made your application.
Lordship may peruse the page 51.
Page
51. Yes. Dated 1st February 2012.
Yeah, just a minute. 51. Recommendation of the board of officer for compassionate appointment. They are not to invite your foundation so in which list of applicants.
It is the 5%.
Yes. No. The Lordship may see the second paragraph. The board of officers constituted by your department or number a policy dated
Decreasing order.
12/1/2012.
The preference that is name of serial number such as most deserving case.
Most deserving or yet our last deserving.
That means along with the petitioner it was considered and found that other deserving can be given. He is not coming on that deserving, that's why he is not given. Yes, admittedly the death is on 10th. Admittedly they have submitted application on 2011 and the resolution was made in 2012. That is a communication from the Deputy Surveyor General of India, Chairman Committee of the Compensation Appointment. He has communicated to the Surveyor General of India.
Subuni, Mr. Paddy, there is some problem.
That is with everyone.
Audio, there is going to body on a shared problem.
May I audible now?
Now, little audible. Please speak. Make your submission once again.
Yes, my lord.
You are referring to that particular annexure that is at 50 number 51.
Yes, according to his application, admittedly the death was on 6/5/2010.
Yes, 6/5/2010. Yes.
And application was submitted on 5/1/2011 within a year.
5/1/2011.
11. According to his application, what I perished, my lord.
5/1.
5/1/2011.
Right.
That means within a year he has submitted application. Accordingly, the committee who is constituted by the Survey of India, the Deputy Survey General of Deputy Survey General of India is the chairman of this committee. He communicated the Survey General of India. That is a communication of page 51. In that consideration, he has observed that the Board of Officers, second paragraph, the Board of Officers constituted by your department order number such and such dated a policy dated 12/1/2012 agreed all 115 impaneled cases in the describing order of the preference. That is the name of serial number is most deserving case and serial number of 115 is the less deserving cases after thorough consideration. That means out of all the appointment of rehabilitation appointment, there is a criteria has been fixed who is the most deserving candidate. The next paragraph page, my learned friend has annexed it. Categories everything is correct. Who is the, whether he is dependent they are not, what is the other income they are not. Many things are there. Taking into consideration of all the criteria, the competent authority found that he is not suitable and others are more suitable for the consider. Accordingly, appointment is given. His case could not be considered.
Oh, in 2012, it's all right. But what happened, Mr. Padhi, in 2011 when he applied it on 5/1/2011, that is the date of application. Whether in 2011 his case was considered or not.
11 case was on 2012 because he has submitted application 5/11.
Oh, acha.
It was on January 2012. It was considered.
Oh, that was considered in January 2012.
Yes.
So what is your submission? In January 2012, your application date is 5/1/2011, and this is the order which has been passed on
8/6/2016.
No. You see that page, particular page, which Mr. Padhi is referring to, page number 51, right? 51 कहुची आपनकर 2011 रे जो माने एप्लीकेशन देले तांकर 2012 रे तांकर गोटे लिस्ट प्रिपेयर हला एवं 15 जन को एम्पैनल करा
Lordship, policy dated 12 January 2012.
Yes, right.
After 1 year of my application. My father's death was in 6/5/2010.
No, आपण जो दिन एप्लीकेशन देबे कोन सेही दिन कंसीडर हे जो कि
नहीं से जो
से तांकर डिसीजन नेइचंती गोटे वर्ष भितर जेतिक एप्लीकेशन आसीबो से माने सेटा को नेक्स्ट ईयर कंसीडर करिवे आपनकर एप्लीकेशन हला 2011 जनवरी रो से माने 2012 फेब्रुआरी रे सबुतक एप्लीकेशन 2011 रो कंसीडर करले ता गोटे लिस्ट प्रिपेयर करले 115 जन जो माने मोस्ट डिजर्विंग तांकर नंबर रहिला 1 रे सेही अनुଯାयी कैटेगरी हला एवं तांकर वैकेंसी पोजीशन दिया है कि देखि किनी जे कंपैशनेट अपॉइंटमेंट पाई केतेटा वैकेंसी अछि ताकू देखि किनी सीरियल अनुଯାयी से देई देले इलीगलिटी ता कोन कले
just I pray one thing, Lord. In parameter to the our state 2020 rules like this, Miller. That has been in Molan the case. They went to Supreme Court and decided the death occurred on the.
Was the rule prevailing according to you? What they should have considered, which they did not consider.
They did not consider on the date of death of the employee.
That what the rule was prevailing. No, that is there. That we know. Which policy was to be considered? Had your application been taken in 2011, which policy was to be considered? Because the authority took into consideration the application in 2012, this policy has been taken into consideration. Now, if your application would have been taken in 2011, which policy would have been there?
You are perhaps making a submission that whenever let us say it is made in 2012 or 13,
yes,
but the date of death is met here, and
yes,
policy which is in existence,
yes, that is Malayananda.
Yes. See that policy in 2010.
What is that policy?
That policy, my lord.
Seta the basis ଆପଣଙ୍କର
ଆପଣ ଯଦି ସେଟା ବେସିସ୍ ହୁଏ 2010 ରେ ଯଦି ଡେଥ୍ ହେଲା ଆପଣଙ୍କର ବାପାଙ୍କର 6/5/2010 ରେ ସେତେବେଳେ କୋଉ ପଲିସିଟା ପ୍ରିଭେଲ୍ କରୁଥିଲା
ଏବଂ ସେ ପଲିସି ଅନୁସାରେ ଆପଣ ଡିଜର୍ଭିଂ ଥିଲେ ଏବଂ ପାଇଥାନ୍ତେ, which having not considered you have not been considered. That should be your case. What is that?
And lordship kindly taken up one week after, my lord, I will clarify your lordship's on that point.
तापरे ए स्टैंड आपण जदी सेठी नै नाहंती
That my lord,
ଆପଣଙ୍କର ସେଣ୍ଟ୍ରାଲ ଆଡମିନିଷ୍ଟ୍ରେଟିଭ ଟ୍ରାଇବୁନାଲ ରେ ଷ୍ଟାଣ୍ଡ ନେଇଥାନ୍ତେ ତାକୁ ସେମାନେ କାଉଣ୍ଟର ଆଫିଡେଭିଟ ଫାଇଲ କରିଥାନ୍ତେ ବର୍ତ୍ତମାନ ଏଇ ଯୋଉ ଷ୍ଟାଣ୍ଡ ଆପଣ ନେଲେ ଏଟା ଫାର୍ଷ୍ଟ ଟାଇମ ନଉଛନ୍ତି while it's a judicial review of the order so can we take off new things which is not there in your pleadings
and that also be Molananda case when I am placing all that
except that if it is legally permissible that means something in law we can take otherwise factual aspect re jodi you also examine that one
in Molananda case ratio has been decided.
Yes, we are aware of that. We are aware of that.
You are telling you but
provided you have taken that plea. Is it your case?
ଆପଣଙ୍କର ଷ୍ଟାଣ୍ଡ ସେଟ୍ ଲା ଯେ ଏଇଆ ହଉଛି ସିଓଟା ମଳାନନ୍ଦ କେସ୍ କେବେ ଆସିଲା decided recently I think what is the date of judgment
reported in 2022 to OLR
yes, yes.
to kebe
22
volume 2 OLR
so if that point of time they considered and there is no this ratio was not there so what illegality they have come consider what illegality they have committed ମଳାନନ୍ଦରେ ପ୍ରଥମ ଥର ପାଇଁ ଯଦି ଡିସିସନ ହେଲା ଯେ ଡେଟ୍ ଅଫ ଡେଥ୍ ର ଯାହା ଇଏ ଥିଲା ତାକୁ ନବ ଏବଂ ସେମାନେ ତା ପୂର୍ବରୁ ଯାହା ପ୍ରିଭେଲିଂ ଜଜମେଣ୍ଟ ଥିଲା କଲେ then what illegality they have committed
no in that case the case of that person was not considered for several years the case of that petitioner had not been considered for several years maybe for 30 years that is how the court has come down to that it is not your case has been considered
judgment gives a retrospective effect specifically state then it has to be applied prospectively so तापरे जो केस गुडाक कंसीडर हबो से गुडाक सेई मान पूर्वरु जो गुडाक कंसीडर हेई जाईछि in accordance with the law which was prevailing then how can it be said if we adopt this thing then everything will be unsettled
and in that case the case of the petitioner was dragged it was never considered in your case it has been considered that is how the court made a very specific observation that the matter has been delayed and finally after 25 years they are saying that no you are not entity so that is deprecated in your case each year your application has been considered
since 2012
all right but if that is your case that had it been taken in 2010 when the policy was favoring you deserving you to be there for compassionate appointment probably your case would have been taken that is your plea where is that plea what was the policy which has not been considered
what do you want
let it come on 1 week after I will
we're taking up on 9th September 2024 during course of argument the Mr. Padi Deputy Solicitor General placed the page number keteda place 51 please the annexures এটা হচ্ছে বোধহয় A1 ଥିଲା না annexure A1 তো সেটা কোন R1 আচ্ছা annexure the counter affidavit filed by the respondent wherein it is mentioned that how the board of officers arranged all the 115 empaneled cases in the decreasing order of preference for consideration top. Mr. Padi submitted that taking into account the vacancies available since the petitioner case didn't come within such a number of this, therefore it was torn down. And right from 2012 till 2016, every year the case of the petitioner was considered, and since the petitioner was not found to be suitable, or in other words, more deserving candidates were available, the petitioner could not get the benefit of compassionate appointment. The Learning Council for the petitioner submitted that the father of the petitioner died in on 6/5/2010, and the application for compassionate appointment was made on 5/1/2011. And in view of the ratio let down in the case of the petition,
Already we have submitted in my written note of hand.
just tipping in the
Synopsis to the reach.
for reference, the authority should have considered the case of the petitioner on the basis of the policy which was existent as on the date of death, that is on 6/5/2010, but they considered the case on the basis of the policy of 2012, na?
Yes.
2012.
And communicated to me, my lord, to 2013.
And communicated the same to 2013.
DOPT number, my lord.
And every year you are receiving the communication.
2013 ମତେ ଯୋଉଟା କମ୍ୟୁନିକେଟ କଲେ ସେ କହିଲେ 2013 ରୁଲ ଅନୁସାରେ, କିନ୍ତୁ ସେମାନେ କାଉଣ୍ଟର ଆଫିଡେଭିଟ ରେ ସେଟା ବର୍ତ୍ତମାନ ମୁଁ ଦେଖିଲି 2012.
No, thereafter you
have a glance which has been communicated to the present petitioner regarding rejection, page 39.
Yes, 39 कौन है ना?
Lordship, first paragraph तले लिखा है जी. Suggested by the government of India, Ministry of Science and Technology Department.
एटा बस 2016 रो लेटर टा.
नहीं हाँ, तादर 1/4/2013 रे से रूल टा फेमस बोली लिखछन.
No, that is another thing. That
has not been communicated to me.
However, he seeks some time, further time, to point the policy which was prevalent in as on 6/5/2010, when the death of the father of the petitioners took place, and list this matter in the week commencing from 9th September 2024. No? That's all. 9th September. Yes.
Item 49.
This writ petition is filed against the order of Learned Central Administrative Tribunal.
Yeah.
And while taking up this matter on 18/7/2024, this honorable court has framed the issue which needs to be decided in this matter. Your Lordship may kindly see the order dated 18/7/2020. Place, my lord. Mr. Ojal, an advocate, appears on behalf of the petitioner and submits two reliefs were sought by his client in the Central Administrative Tribunal. Second relief was regarding seniority denied. He submits the matter of seniority is to be guided by the office memorandum dated 10th September 1985 and 12th December 1988 issued by the Department of Personnel and Training. He relies on paragraph 2 of the second memorandum reproduced below. The matter has been re-examined by recent judicial pronouncement and it has been decided that instructions quoted above may continue to be followed subject to the modification that among the person in the feeder grades given the same grading, those in higher scale of pay will rank senior to those in the lower scale of pay. The Central Board of Direct Taxes (CBDT) issued instruction dated 6th April 2009 in the matter. His client claimed to relief regarding seniority was denied upon reliance upon the instruction. Paragraph 2 in the instruction is reproduced below. The clarification relating to qualified years and enters a seniority with respect of the ministerial and stenographer grade as arrived at the meeting has since been approved by the chairman CBDT. A copy of the note containing the approval note such and such is enclosed. He draws attention to paragraph 11 in impugned order dated 9th April 2019 made by the CAT to demonstrate there was noting of no conflict between the DOPT guidelines and said instruction interpreted as guidelines issued by CBDT. Therefore is not based on the material available. He submits further, his client was in feeder post of stenographer drawing higher scale of pay than ministerial staff. The other feeder post, both of which contributed to filling up promoted post of inspector income tax. Mr. Agru, learned advocate, Central Government Council, appears on behalf of the Union of India. He will be heard on urgent date regarding how the instruction to have been interpreted as a guideline. Furthermore, there must be demonstration of no conflict between the relied upon guidelines of the DOPT. But here the issue was the petitioners also opposite party number 4, 5 and 6. They were promoted to the post of income tax inspector in the recruitment year 2009-10. Thereafter, when 2015 the seniority list was published,
2000
for the recruitment year 2009-10. They were
9-10.
2009, 2010.
Okay.
When seniority list was draft seniority list was published in 2015. Objecting the same, the present petitioner made the representation before the authority indicating that since 3 ministerial staff promised to be made 3:1. 3 ministerial staff, 1 stenographer. But I being the stenographer, I was in higher scale of pay, that 5,500 to 9,000. And ministerial staff, their scale was 5,000 to 8,000. Then I objected to that, indicating that since they were getting the lower scale of pay at the time of promotion, therefore they will be placed below me in view of the DOPT guidelines. But that has not been considered. Rather, the final seniority list was published. But when I approached to the learned tribunal for the first time, the law said that you consider the authority should consider the representation and pass the speaking order. The authority, they have passed the speaking order indicating that your lordship may kindly come to that speaking order. That is at Lord page injection. Your lordship may kindly turn to page 109. That was improved before the learned tribunal. Your lordship may relevant portion is at page 114.
114.
114. Running page, internal page, 97. Paragraph 60.
Yes.
The DOPT's guidelines, as mentioned above, are applicable in conjunction with the relevant recruitment rules. framed and notified by the Income Tax Department with the approval of the DOPT. In fact, DOPT's guidelines are modified by the CBDT. You'll also mark it blood. The DOPT's guidelines are modified by the CBDT, while its clarification dated 6/4/2009 in accordance with the recruitment rules for the post of IIT. The modification of the CBDT is to the extent of fixing seniority between ministerial staff and stenographers by taking into account the mode of selection of candidates for promotion from the respective groups in the ratio of 3:1 as provided in the recruitment rules. The CBDT's clarification by letter dated such and such as under. As regards the 3 years qualifying service, it was agreed that this will relate to the cumulative length of service in the respective ministerial grade and the stenographer's grade with respect of individual grades of office superintendent, senior TA, UDC, stenographer 1, 2, and 3. For the purpose of working out seniority in the panel to be drawn by the DPC, the present practice is to draw 4 lists. 2 in the ministerial and 2 in the stenographer's grade. 1 list based on the seniority and other based on the years of passing of the departmental examination. For example, if the last official in the previous panel was stenographer, year of passing, for the purpose of filling up the quota of 3:1, the sequence of ministerial list based on ministerial list based on the year of passing, ministerial list based on the seniority, and a stenographer's list based on the seniority is to be adopted as under ministerial seniority, ministerial year of passing, ministerial seniority, and stenographer seniority. Lord, this is the sequence they have framed in the whatever clarification they are saying. Lord. You will also kindly see that clarification first. Lord. That is at page 250. That is at page 117. Just thereafter that time. Thereafter. Treating this is the clarification. They have override the DOPT circular. You will also kindly see. 6th April 2009. Page 117. Dated 6th April 2009. Such and subject, you will also kindly take note of. Subject, CAT Kotak Bench notice in OA number such and such, relating promotion to the post of Inspector of Income Tax. I am directed to refer to the meeting held on 1st April 2009 with regard to the above OAs filed by the ministerial grade officers for promotion to the post of Inspector of Income Tax. The clarification relating to qualifying service of 3 years and intercept seniority with respect of the ministerial and stenographer grade as arrived at the meeting has since been approved by the chair. A copy of the note containing the approval, note number such and such, is enclosed. It is requested that appropriate replies to the above OA may kindly filed in consultation with the Central Government Standing Council at the earliest. Then your lordship may kindly see the note next page. This is the note it was prepared to file the counter, but now the authority, they are treating the same as the circular, and on the basis of that they are overriding the DOPT circular and indicating that by virtue of this note we have modified the DOPT circular.
No. The DOPT circular has been clarified in coherence with the rules of CBDT. What is that?
Well, the rule is
if the rule is not in conformity with the guidelines given by the DOPT, then where the loopholes lie?
The rule is the recruitment rule.
Yes.
And the recruitment rule.
No, only recruitment or promotion?
The recruitment rule,
that includes
promotion rule, 1969.
Right.
But there, how the seniority, intercept seniority is to be fixed, that is not there.
Not there.
That is the DOPT guidelines only govern so far as the central government employees are concerned.
It is not there. That is how the DOPT is guideline has to be followed.
DOPT guideline is to be followed so far as central government employees are concerned. DOPT circular I have also included where it has been specifically indicated how the seniority between the various grades, seniority, inter-seniority between the employees promoted from various sources that has to be. It has been indicated if the persons are coming from various sources and through one DPC they were promoted, their quota is to be according to their quota they will be promoted. However, while fixing the inter-seniority, then the DOPT has clarified that the person who was getting the higher pay prior to the promotion, then he will be treated as senior.
Senior in the gradation list.
Yes, inter that you also may kindly see that.
Yes, whatever is there.
That circular you also.
The DOPT circular.
Yes. That your lordship will find that is at case law 199.
Annexure 6.
Annexure 6 in the OM that was.
Yes.
Here, paragraph.
General principle of seniority preparation.
Your lordship may kindly see that paragraph subpara 2 that makes how the seniority is to be fixed. Reference have been received in this department seeking guidance in the matter of preparation of consolidated order of merit where quotas for the feeder grades have been let down in the recruitment rules. Here, 3:1 has been let down. The matter has been examined in the department in consultation with the Union Public Service. It has been decided that where the posts in the feeder grade are in different scales of pay or even in the identical or equivalent scale of pay, the officers up to the number of vacancies for each feeder grade as per the quota may be selected and interpolated in a combined select list according to the grading. The persons who are assigned the same grading by the DPC should be arranged in the consolidated under the
order of merit. Consolidated order of merit.
With reference to the date arrived at after adding the requisite number of years of qualifying service in the feeder grade to their date of appointment. That is with reference to the date from which they become eligible for promotion after rendering the prescribed qualifying service in the feeder grade, maintaining their inter-seniority in the parent service grade. Then this circular again was clarified and modified. Next page 201, your lordship may kindly see. 12th December 1988. The undersigned is directed to refer to this department OM dated such and such that earlier 1985, which lays down the procedure for preparation of a consolidated order of merit where quotas for feeder grade have been let down in the recruitment rules. According to the instructions referred to above, where the post of feeder grade are in different scales of pay or even or equivalent scale of pay, officers up to the number of vacancies for each feeder grade as per the quota have to be selected and interpolated in the combined select list according to the grading, and persons who are assigned the same grading by the DPC have to be arranged in the consolidated order of merit with reference to the date arrived at after adding the requisite number of years of qualifying service in the feeder grade to their date of appointment in the grade, that is with reference to the date from which they become eligible for promotion after rendering the prescribed qualifying service in the feeder grade, maintaining seniority in the present service and grade. 2. The matter has been re-examined in the light of recent judicial pronouncement and it has been decided that the instructions quoted above may continue to be followed, subject to the modification that among the persons in the feeder grade given the same grading, those in the higher scale of pay will rank senior to those in the lower scale of pay. My case is rest there. If your lordship will come to paragraph 4.10, that is at page milord. page running page 30 mila. Internal page 13 of the way and the running page 30. May I bless you?
Yes.
That the applicant has been promoted to inspector of income tax from the feeder cadre of stenographer, drawing pre-revised scale of pay rupees 5,500 to 9,000 during the recruitment year 910. The respondent number 4 to 6, here the private opposite parties will not, have been promoted to the post of inspector income tax from the feeder cadre of ministerial, drawing pre-revised scale of pay rupees 5,000 to 8,000 during the same recruitment year. Though the applicant reached the scale of pay 5,500 to 9,000 during the year 2007, whereas the respondent number 4 to 6 have never reached to the said scale of pay at all till their promotion to the inspector income tax during 2019. The equivalent grade having scale of pay of rupees 5,500 of the ministerial cadre is erstwhile supervisor, grade 2 office superintendent. The respondent number 3 has published list of supervisor grade 3, grade 2 office superintendent from the year 1986 to 87 and 2008 to 9 by order dated such and such, in which the name of the private respondent do not appear at all in any recruitment year. That means the respondent number 4 to 6 have never reached to the above scale of pay equivalent to that the applicant up to recruitment year 910. Rather, they have got to the post of inspector from the grade of head clerk, assistant, senior assistant, belonging to the ministerial cadre, having scale of pay rupees 5,000 to 8,000, which is lower scale of pay than that of the applicant. It was my clear case before the law and tribunal. But with the two prayers I moved, after filing that challenging that order before the law and tribunal, they immediately, in 2017, I filed the case in 2016. 2017, they again changed my recruitment year from 2008-9 to 9-10 to 10-11. And by way of amendment, I was also within the purview of that case. And while considering the matter, law and tribunal passed that order directing that this person will be treated from 9-10. So far as the second part of my prayer is concerned, that I must be treated as senior to all those three other persons. That part law and tribunal has rejected, and you will also may kindly turn to the law and tribunal's order on what ground he has rejected. That is at page 182, law and tribunal's order. Internal page 189, paragraph 11.
Yes.
Regarding the issue B relating to the seniority of the applicant vis-a-vis the respondent number 4 to 6, we also do not find adequate justification in the pleading of applicant in support of his contention in this regard. As stated by the respondents in the impugned order dated 1/8/2016, the seniority is required to be fixed as per the selection rosters as per the CBDT guidelines dated 6/4/2009. And it is noted there is no conflict between the guidelines and the DOPT guidelines. In the representation dated 18/8/2015, the applicant has extracted the DOPT guidelines, which states as follows, that I have already submitted. It is seen from the above that the argument of the applicant that the person which higher scale of pay should rank senior with those of the lower scale of pay at DOPT guidelines is applicable for the employees with the same grading assigned by the DPC, and in that case, candidates with a higher scale of pay will be assigned higher seniority. Otherwise, grading given by the DPC should be on the basis of seniority in the consolidated order of merit. Hence, the averment in the way that the applicant should have been assigned a higher seniority compared to the respondent number 4, 5, 6 because of higher scale of pay, higher pay scale at the time of promotion to the IIT is not in accordance with the DOPT guidelines referred in the way. The applicant has also cited the order dated 15/9/2017 of this tribunal in way number 109 of 2011 in the case of Chittaranjan Panda, Secretary of Government, Department of Revenue, Ministry of Finance, same department, in which the principle of a candidate drawing a higher pay scale to have higher rank in seniority list of IITs was accepted. It is seen from the order dated 15/9/2017 that the applicant in way number such and such was assigned higher position in the seniority list by the DPC for recruitment year 2006-07, which was modified by the respondent subsequently. In the present way, before us, the applicant was initially placed in the recruitment year 2008-09. It is noted that the 6th Pay Commission recommendation with effect from 1/1/2006 have been implemented by the government in 2008, and after that, the pay scale 5,000 to 8,000 and 5,500 to 9,000 have merged to one pay band. It has not been clearly demonstrated by the applicant in the way that after implementation of the revised pay as per 6th Pay Commission, if the applicant was getting higher pay scale than the respondent number 4 to 6 during the recruitment year 2008-09, when he was considered for promotion to the post of IIT. It is factually distinguishable. Accordingly, the issue B of para 8 is decided against the applicant.
So where is your document with respect to this?
Your Lordship has gone through that paragraph 4.10 where I have specifically indicated I was getting 5,500, they were getting 5,000. Then your Lordship may kindly turn to running page 223. Learned Tribunal failed to take note of all those rules. 220. Perfect. The internal page 8 of my agenda. That is dated 13th September 2000.
Which paragraph?
I will place next page, my lord. Page 224. Paragraph 2.
204 or 224?
224. 224. Paragraph 2, my lord. Your lordship mechanics.
Paragraph?
Exactly my position is that.
No, paragraph?
That italic 2.
Italic 2. Roman 2.
Roman 2. Sorry. Where
yes, sir.
Where posts having different pay scales prior to 6 CPC recommendation and now after merger have come to lie in the same pay band with the same grade pay. The inter-se seniority of all the employees will be fully maintained with employees in a higher pre-revised pay scale being placed higher vis-a-vis an employee in the lower pay scale within the same pre-revised pay scales seniority which existed prior to the revision. Lord, even if that has been merged, then
no, it has been clarified.
Exactly, Lord. Then prior to 6 CPC came into effect, I was getting 5,500 scale, and they were getting 5,000.
Where is that? That pay scale, where have you annexed the document? That your pay band is 5,500, 175.
So, one to my way, that was my pay scale, and paragraph 4.10, I have already indicated that has not been disputed or denied.
So, they were getting 150 and you were getting 175. You were higher in the pay band.
I was getting 5,500 scale.
Scale with 175 and 9,000.
Yes.
They were getting 5,500, 150 with 8,000. 5,000 with 8,000.
Yes. Therefore, pre-revised scale, I was getting also.
Annexure 1. Annexure 1.
Annexure 1 page, my lord. Page 46.
Yes, yes.
Kindly see.
Sri Sapan Kumar Mahanti.
Yes, ma'am. 5,000.
Joined as stenographer, grade 1.
Yes, ma'am.
on 3/9.
17th September 2007, I got 5,500. Stenographer grade 1. And that I have specifically indicated in para 4.10.
No. You stick to 46 first. What is that?
Yes, brother.
What is that?
This your lordship kindly third sub-para third.
Increment is 150 years.
In the same scale of pay, rupees 5,500, 175, 9,000 with effect from 3/9/2007. Your lordship.
Pay fixed in next days of the time scale of pay 5,500, 175 with effect from 3/9/2007.
Much prior to the promotion, I was getting that scale of pay. It is not in dispute that I was getting higher scale. But only Law and Tribunal has said, since it was the most after 6 CPC came into effect, therefore it is difficult to point out how the fixed on the basis of that DOPT circular.
No, that is.
Now it has been clarified by the DOPT. The steel miller, they are continuing as senior to me in the intersection seniority. So far as first part 2019, that has been resolved because the Law and Tribunal has granted that benefit. But this aspect, Law and Tribunal has rejected by saying all these things that CBDT 6/4/2009 letter will be treated as a circular.
That is clarification to the.
Now, how the seniority will be fixed after the 6th pay commission has been the person who was getting the pre-revised higher scale will be the person to be placed in the seniority.
What will the scale of pay?
After the merger, when the pay scale becomes same, then how the seniority is to be fixed. And that is clarified. It is to be reckoned on the basis of the pre-revised scale. So why that is not taken into consideration?
But my brother is submitting, this restructuring was given to pursuant with the direction of this honorable court, so also honorable.
What is that? That means
the counter.
No. What is this court and this court?
We have simply mentioned that. In para 6 of my counter at page 204.
204?
Yes. Running page 2 of my counter. With regard to the
Yes,
204. 204.
Yes.
Yes.
With regard to the amendments made in paragraph 4 of the petition.
Para 6.
Yes, sir. The deponent, following the implementation of the order dated 10/5/2011, passed by this honorable court in WPC number 19289 of 2010, Niranjan Behra versus Union of India and others, on the issue of promotion on own merit in the grade of ITO. Review DPC in the grade of Inspector of Income Tax was held for the recruitment year 2007 to 8 to
10/11
on
4/8/2011.
In the said review DPC, had been nationally reverted in the grade of IIT for the recruitment year 2008-9. Nationally reverted.
Right.
To recruitment year 2009-10 by order dated such and such dated 5/8/2011. In the said order, the seniority of the petitioner was fixed in the ratio 3:1 of the ministerial and stenographer as clarified by the CBDT, Central Board of Direct Taxes, in its letter dated 6/4/2009. That is the clarification which is in question mark. What my brother is questioning. And the petitioner was rightly placed in the said order as he belongs to stenographer grade and the opposite party, number 5 and 6 belongs to the ministerial grade. 4, 5, 6 belongs to ministerial grade and the present petitioner belongs to the stenographer.
Yes, he is coming in 3:1.
While maintaining the seniority, gradation list is to be taken at 3:1. 3 from the
ministerial, 1 from the stenographer.
Therefore, the seniority of the petitioner has been rightly fixed following the recruitment rule in the grade of Inspector of Income Tax and the clarification of CBDT dated 6/4/2009 as recommended by the DPC and being approved by the competent authority. Hence,
No, that is internal matter. We are not on that. That is an internal matter. The question with regard to the court in WPC 192/89 of 2010 in the matter of Niranjan Behra versus Union of India, the promotion, reversion of the petitioner. Who is that petitioner? The reversion of the petitioner he was one of the party.
Yes.
You were one of the party there.
May I clarify?
Let us
a case when the Honorable High Court has allowed that writ petition.
Right.
Initially, I was recommended for 2008 and 9.
Yeah.
Then when Niranjan Behra, the court has directed that he should be interpreted 8-9.
Right.
Then suddenly, I was pushed back to 2000.
Not suddenly. It was, yeah, of course, you might be getting the higher scale of pay, but notionally you were reverted.
Yes, I was.
So the benefit, whatever was to accrue to you in 8-9, was to accrue from that. Notionally, what you have been reverted.
I am not asking for 8-9.
Yes. No, what he is saying.
I'm not asking that.
What the direction has been passed in WBC. That is what.
That I have accepted.
Right.
I have not challenged that.
Right.
Then they have granted me 2000 DPC was in 2011. They have again considered 2019.
So this is considered. How he is affected?
No,
how is affected?
not at all, man. And the Lawrence Tribunal has also allowed the oil.
Yes.
The
When it's been allowed.
Yes, man.
And
You have to glance to the food order, man.
let us see. So why have you come here then?
Page 194.
Page 194.
Para 15.
194 of your agenda.
No.
Or way order.
194 of the board. Para 15.
Yes.
We are therefore of the considered view that the informed order dated 1/4/2017 in respect of the applicant is not sustainable. Accordingly, the said informed order dated 1/4/2017 in respect of change of recruitment year of the applicant from 2009-10 to 2010 is set aside only and for the applicant. The respondents are directed.
So your recruitment is for what? 8-9, pra?
9, sir. 9-10.
9-10. So and
9-10.
So 9-10 is set aside.
No, sir.
9-10
टाको ସେମାନେ during pendence of this way before the tribunal ସେଟାକୁ 10-11 କରିବେ ତେଣୁ ମୁଁ amendment ସେଟା challenge pass ହେଇଗଲା କିନ୍ତୁ inter seniority only issue it before your lordship that so far as recruitment year 2009-10 that has been granted by the law.
Respondents are directed to fix the seniority of the applicant as Inspector of Income Tax treating his recruitment year
9-10
instead of 8-9, that is 9-10.
9-10.
So
Accepted.
For the seniority,
this also you have accepted.
I have accepted that part. But one part they have the Lorna Tribunal rejected that inter-se seniority between the minister and myself.
Where is that? Where is that? Where is that?
Exactly.
Operation part of the 9.
Exactly. Your lordship kindly turn to page 191.
191. But that is not in. That might be an observation. But operation part is what?
According to the issue, your lordship kindly see. According to the issue B, para 8 is decided against the applicant.
Para 8.
Just paragraph 13 उपरକୁ जो first line. Two issues were framed. So far as one issue, I have decided in my favor directly that I will be there 9-10.
Three from the ministerial and one from the stenographer. That ministerial staff will be.
Now you read the operation part again. Mr. Roja, kindly read again. We are therefore
considered view that the impugned order dated 1/4/2017
In respect of the applicants.
A by 13 in respect of the applicant is not sustainable.
Correct.
Accordingly, the said impugned order dated 1/4/2017 in respect of the change of recruitment year of applicant from 2009-10 to 2010-11 is set aside only for the applicant.
Yes.
The respondents are directed to fix the seniority of the applicant as Inspector Income Tax treating his recruitment year 2009-10 as per the seniority list dated 14/9/2015 annexure A by 6 and allow the consequential benefits as per law to the applicant after restoration of his seniority as above. They have fixed my seniority in accordance with the recruitment year 2019.
Is the seniority list which you are hampering 14/9/2015?
Yes, Milord. They are Milord. Milord, my humble submission.
That has not been challenged.
Here, Milord, your Lordship may kindly see 1/4/2017 the London Tribunal has passed. That is the seniority list also.
Yes.
There I have been placed in 2010-11. And that has been passed and directed that my seniority be restored in accordance with 2015, where it has been indicated that my recruitment year is 9 and 10.
Come to annexure A6.
Yes, Milord. That is at phrase, Milord. Page 86, Milord. Page 86. This is 14th September.
Yes, 14th September 2015.
Yes, on the basis of review DPC and in consonance with the NR Farmer case, they have prepared the seniority list. Your Lordship may kindly turn to page 88. They have reviewed DPC as per the recommendation of the review DPC. My name is there for 2009-10.
So this is in consonance with MR Farmer case.
Yes, in our Farmer case.
Yes.
Yes. Farmer case, recruitment year they have allotted me 2009.
We have also completed in our counter manner.
I'm not challenging 2009 and 10 recruitment year.
Yes.
I'm only challenging that you.
But that is not your case.
Yes.
That is
not your case.
Yes, that is the case before the Law and Tribunal. Law and Tribunal rejected my application that enters a seniority between the 4, 5, 6 and myself. That part Law and Tribunal has rejected in paragraph 12 below, indicating that issue B has been decided against the petitioner.
In view of the NR Farmer case matter, the entire
I'm not.
That's why he's agreed. Why my seniority will be devoted to 2009 instead of 8.
So according to you, it is not in the operational part of the order of the OA. Yes. Rather, the observation that they have made in para 12 of the.
Exactly, Malad. Initially, yes. I approached the Law and Tribunal challenging inter-se seniority fixed between the 4, 5, 6 and me.
That we understood.
And then that was pending the 2017 DPC.
Sir, that we understood. That has been set aside.
That has been set aside. But so far as the inter-se seniority part is concerned, for which the first case was initially filed, that was rejected by the Law and Tribunal, saying that since the pay scales were more, you will not get the at this stage the tribunal cannot direct. And that is my limited grievance before your lords.
But that is not the order in the way.
No, Law and Tribunal that part they have rejected, saying that it is decided against the petitioner, my lord. That means if your lords said that the Law and Tribunal has not decided that part, that means that issue has not been decided.
Well, that my client of my learned brother was given also granted consequential benefits fixing seniority.
If that is so, how are you? They say that the consequential benefit has been awarded. And have you got the consequential benefit, but not in according to you, not in accordance with the seniority in the gradation list?
Yes. I got the.
How are you?
I got the consequential placed me in 2019.
910. That you accept.
That
you have accepted.
That is the consequential they have given.
And that you have accepted.
Yes, I have accepted. But they have not reshuffled my seniority in reference to the.
We take tea at a time, cool drinks.
No. Wants to have the ham as well as the egg.
Already.
अच्छा सारा ताले मु कहू
नहीं कहू we are नहीं
my humble submission, my first case was before the law and tribunal that interest seniority between 4, 5, 6 and myself be refixed in view.
Issue that is framed in paragraph number 8, that is page number is 187.
Yeah.
So if you carefully read it, these three issues, then the observation as per the CAT judgment, issue number A and B that has gone against you.
Me.
C has gone in favor of you.
Yeah.
Once C has gone in favor of you, then it also has an impact on this issue number A and B.
Because issue number A, I am clarifying that. Issue number A, that my prayer was I may be given the seniority for the recruitment year 2008-9. Issue number B, that I may be given the interest seniority between 4, 5, 6, that may be refixed. Issue number 3, that my seniority refixed for the year 2010-11 may be quashed. Law and Tribunal, so far as 2008-9, Law and Tribunal decided the issue against me. So far, issue that interest seniority between the 4, 5, 6 and myself, that issue was also decided against me. But so far as quashing up that 2017, fixing my seniority for the recruitment year 2010-11, that issue decided in my favor. I have accepted two issues. To 8-9, the Law and Tribunal said you are not entitled to 8-9. I have accepted. Law and Tribunal quashed that. I have accepted. But so far as my prayer number 2 made in the original application, that to declare that the applicant is a senior to the respondent number 4 to 6 in the Inspector Income Tax cadre as per DOPT circular issued to that effect, which has been decided against me, against that order, I am before your lordship. That issue, the Law and Tribunal decided in a wrong, bypassing the DOPT circular, which is very much clear and unambiguous. There, the DOPT has said, when the persons are coming from different sources and considered by the DPC, they were promoted, the interest seniority between the parties will be decided in accordance with that circular. But the person who was getting the higher scale of pay, he will be treated as a senior from among them. But I was getting the higher, because it is 3:1. All three persons were getting lower scale of pay during the 9-10.
That is your exactly grievance against that seniority list dated 14/9/2015, which is annexed as Annexure A by 6. Come to that Annexure A by 6.
Page 88, your lordship may kindly see.
Come to Annexure A by 6.
A by 6 is 86, my lord.
86, okay.
Your lordship relevant is at page 88.
88, yes.
Your lordship may kindly see top 2009-10. Recruitment, this is the recruitment. Yes, I am coming, my lord. Your lordship may kindly see S.K. Rajan. S.K. Rajan. Opposite party number 4. D.P. Acharya, opposite party number 5. M.R. Mishra, opposite party number 6. My name, my position, they have indicated at serial number 7, S.K. Mohanty.
Serial number 6 is the direct recruitment, therefore I have no quarrel with him. These 3, 4, 5, they cannot, 3:1, they have selected for that year. These 3 persons were getting the less pay.
That is your case.
Yes. That while the DPC was head, and the DOPT makes clear, my right flows through that DOPT circular only.
Prior to merger, they were getting less scale of pay.
Yes.
So when the merger took place, since you are getting the higher scale of pay, your placement should have been above them.
Exactly.
That is your case.
That Supreme Court has DOPT has clarified.
So what is your answer to this? Why she is
In merger, you are not right. In the pre-revised, you are.
merger also नहीं सर merger रे भी higher पाई केमिति ना fixation हबो सेतेबेले भी मु अधिक दरमा पाइबी किंतु but I am not going to that aspect. Pay matrix रे जतोल even I was getting the higher pay, when the pay matrix, my pay will be fixed on the basis of pay level and pay matrix, I will get the higher pay. But I am not exactly. Oblige.
You want a reshuffling of your land.
Yes.
In the
above.
You mean to say that you should have been in number 3 and not number.
These 3 persons should be below me.
Exactly.
You have
not been answered by the way.
Only on the ground that since pay has been
if his name will be over them, then it amounts to reshuffling of the gradation list. And man, kindly have a glance to para 8 of my
But when you have taken a decision that if they come to before merger, if they have under different scale of pay, once the merger takes place, the person who is getting the higher scale of pay, that is to be placed above the persons who are getting the lower scale of pay. Then how this thing has happened?
After merger, the lower scale of pay and the higher.
That is one, but the placement is relevant. Placement upon one that is right. They will get now the pay scale would be 1, but their placement in the seniority list would be based on the intercy which you are on the basis of the scale of pay. That is
in a contingency when such a situation arises, how to reconcile with that? Clarify. The person who was in
by virtue of that
pre-revised is to be placed higher.
Right.
That is it.
That clarification matter, it was clarified. That my learned brother is submitting, that is a guideline. That is not a guideline. 6/9/2000.
Guideline that is
clarification. That is the clarification to the guideline of the Duke.
No, guideline रे ambiguity थिला बेली clarification तो मगा गला clarification मगा गला परे आपण कोडी कहले जे ना एटा clarification ता ठीक नुहे आपण किछि कहिसेंदी ए clarification को आपण observe करिवे आपण ambiguity
clarification बेस करके दे
एही नि बरा एटी देखो ना केम से तो को जे ना
I am going to that para 8 of my count 206 page number 206. That with regard to the amendment made in para 6 of the reputation, the deponent begs to state that subsequently, while implementing the direction of the Honorable Supreme Court in case of N.R. Parmar, a reviewed PC in the grade of Inspector of Income Tax IIT was held from the recruitment year 1986 to 87 to 2014 and 15. On the basis of recommendation of the reviewed PC, and after being approved by the competent authority, revised senior list in the grade of IIT was circulated by the order dated such and such 1/9/2015 and order dated 14/9/2015. In the said revised senior list, the petitioner was given seniority with effect from 3/8/2009. That's why his seniority has been fixed 2009-10, madam. And for the recruitment year 2019 and placed junior to the opposite parties 4, 5, 6 as recommended by the review office.
ସେମାନଙ୍କର ଇଏର
That review DPC cancelled anywhere.
ସେମାନଙ୍କର ରିକ୍ରୁଟମେଣ୍ଟ ଇୟର କେବେ ଯୋଉ 4, 5, 6
910. NR Palmer case only clarifying with regard to fixation of seniority recruitment year.
That's why. That's
That recruitment year. I am not challenging that recruitment year.
But the challenging is not the question whether the mandate of the Farmer case
Yes.
is followed.
Yes, they have followed. Yes, my lord, they have followed and they have fixed our. Therefore, in place of 8-9, I was placed in 9-10, and that I have accepted, my lord. That says recruitment year.
If that is so, according to their counter,
Yes,
your
ma'am.
seniority has been taken, you expect from 3, 8.
Yes, ma'am.
9, my lord. Then recruitment year 2009-10. Then, my lord, there is no dispute. But when you are placing me in recruitment year 9-10, three ministerial staff were recruited, that promoted. I was also promoted. Therefore, how the inter-seniority between the ministerial staff and the stenographer is to be fixed. That is the DOPT circular. That is only my grievance. NR Palmer case, there is no dispute. NR Palmer case, you have followed, refixed the seniority, recruitment year, all other things. I have no grievance, my lord. ଆଜ୍ଞା
who is appearing for this respondent?
They are not contesting. In fact, they are appearing. They are also, they are not contesting.
Your notice sufficient.
Yes, they one counsel they have given, but they are not appearing. But they know very well because they are the juniors.
This is item number
49.
49. Whether anybody is appearing for this 4, 5, 6 na ketna?
ଆଜ୍ଞା 4, 5, 6 ପାଇଁ appear କରୁଛନ୍ତି Mr. Sarveshwar Barik and other counsels.
अच्छी नाटा सर्वेश्वर बारिक केस
They are not contesting.
Thereafter, para 10.
No, they are likely to be affected. Why they are not contesting? What you say?
नहीं सर सेठी सेमान तो बिल्कुल अपियर कर नथिले रण ट्राइब्यूनल ले जदी नोटिस आइतला एठी नोटिस गला पर दी थर नोटिस गला पर समान अपियर कर गले बट दे आर नॉट contesting.
You say that they are not interested. That is why
because they are very much
you fear you will go above them. So they are rightly they are likely to be affected.
In that process, they are not going to lose anything more, Mila. Because already been promoted ITO or no, Mila. In future, Mila, I have already got
correct. That is not correct. Another thing is that, man, by the recommendation of the review DPC, we have fixed his seniority. We have clearly mentioned that. As per recommendation, his seniority was fixed 3/8/2009. That's why, my lord, tribunal has consciously passed that order. And his seniority has been fixed and consequential benefits have also been granted. And thereafter, my lord, para 10. My lord. Page 2006.
Tribunal has not gone to that aspect. They have said since merger is there, you will not get that.
They have gone to the basics of the scale of pay.
Yes.
Had the matter been gone into the scale of pay, you would have not.
Yes.
But my lord,
we are thinking of whether Mr. Barik has missed the list or he is deliberately not appearing.
Last occasion was present.
No, we are proposing to reserve the matter or judgment, but the thing is that his name is very much there, but sometimes it happens that so uh, so can intimation be given? We can take up this matter on Tuesday. Just you give the intimation. If he's still not interested,
Yes, yes,
it's
yes,
all right
I'll give
because
them.
almost the argument is closed. So, but to if you'll have his say or not, that depends upon him.
I'll let
But let's not complain somewhere that
Yes.
afterward that
No.
I have missed the list and all these things. So
Yes.
Yes, yes. That para 10, you will have to that you have to clarify to example that you have mentioned in page 207. Only you need to explain that because a clarification has already been given that the interstate seniority is to be fixed on the basis of the pay. You have fixed it, not in accordance with pay.
It's supposed to be in a farmer case or disability.
All right, you will show it that day. And Tuesday clarify it.
the Hardy Land Council for the petition, for the Land Council, Central Government Council. However, it appears that though for opposite party number 456, Mr. Sarveshwar Behra Bari and his associates have filed power, but nobody is appearing. The Land Council for both the parties submit that they will intimate Mr. Bari that the case will be listed on 20th August 2024 for 20th, 27th, 27th August 2024. So this
21 ହଉ କି 28 ହଉ ହେଲେ so that supplementary list ରେ ଆସିବ।
28th August 2024. Second September 2024, that it will be taken up for further hearing.
Sir, second weekly list ରେ ଆସେ ତଳକୁ।
You want it to come in the supplementarily. Then it come third. Third September 2024, and they will intimate Mr. Bari.
Yes.
Okay.
I may be, pardon me, Lord. Item 79. There is a noting regarding the sufficiency of notice and issuance of fresh notice. Let it come next week as the orders, Lord. Item 79. Next week for orders, Lord.
It's a counter affidavit filed by what?
Counter affidavit filed by the Union of India. There are several 30 opposite parties are there, private opposite parties are there. So notice of some of refusal, they have.
That is to be made sufficient.
Yes, the fresh notice where they not. Then let it come for orders next week, so that
79 is for orders.
Add-on to man mention, my lord. Item 50, kindly give me any short date for filing written argument and memo.
Come on 27. That is the shortest date we can give because tomorrow is the single match. So what do you want? How can be shortest date?
Next week.
That is 27.
Of this text of next week, maybe.
Yes.
That's yours.
Supplementary list, item number 1.
That's it. The king in well custody since 11 years. Now, like, this.
It's very that who is that person? The advocate's lawyer. Come here.
Submit to advocate.
सर्टिफिकेट आनी आपन की देथलो
मुझे सर सर्टिफिकेट के देना भी
आपन को तैयारी करले
मु सर जाने नि मते खाली कहले एफिडेविट करिया कोई बाबू तांकर एफिडेविट करछि खाली कहले एफिडेविट रे दस्तखत करो बोली मु सर दस्तखत करछि मु आ किछि सर देखिनि कि जाननी
ଆପଣ ଯେତେବେଳେ advocates club ଯେତେବେଳେ ଦସ୍ତଖତଟା କରୁଛନ୍ତି ସେ ଯୋଉ affidavit portion ରେ କଣ ଲେଖା ହେଇଛି ତାକୁ ପଢିଥିଲେ
मु सर के देखेलिनि मु मते कहले दस्तखत करथिया मु गोटे फाइल करबी मना कला परे मते
ଏଟା ଦେଖିବେ ସେ ଆଇଏଟା ବାଛନ୍ତି ଏଇ ଯୋଉ the IE on which we pass the order ଏଇଟା ଆପଣ ପାଠ କୋଉ ଯାଏ ପଢିଛନ୍ତି
मैट्रिक जे सारे पढ़छि
मैट्रिक पास କରିଛନ୍ତି
आज्ञा
କେବେ ପାସ୍ କଲେ matriculation
ये सारे 89
1989 କୋଉ ସ୍କୁଲରୁ
आज्ञा जो हमर सरंडा विद्यापीठ सरंडा विद्यापीठ बांकी आज्ञा कटक डिस्ट्रिक्ट
କୋଉ ଡିଭିଜନରେ ପାସ୍ କରିଥିଲେ
थर्ड डिवीजन
सर्टिफिकेट ଅଛି ଆପଣଙ୍କର
आज्ञा
HSC ପାସ୍ सर्टिफिकेट
आज्ञा
affidavit ଯୋଉ ଇଂରାଜୀରେ ଲେଖା ହେଇଛି ଆପଣଙ୍କର ନାଁ ହଉଛି ଜନାର୍ଦ୍ଦନ ସେଠୀ
आज्ञा
ବୟସ ହଉଛି 48 ବର୍ଷ ବାପାଙ୍କ ନାଁ ଦିଗମ୍ବର ସେଠୀ ଘର ହଉଛି ତେଲେଙ୍ଗା ବଜାର ଥାନା ହଉଛି ପୁରୀଘାଟ ଜିଲ୍ଲା କଟକ ଠିକ ଲେଖା ହେଇଛି ତ
आज्ञा
ତା ଛଡା ଲେଖା ହେଇଛି ଆପଣ ହଉଛନ୍ତି ଏଇ କେସ୍ ର ଆଡଭୋକେଟ କ୍ଲର୍କ ଏକଥା ମଧ୍ୟ ଠିକ?
ଆଜ୍ଞା।
ତାପରେ ଲେଖା ହେଇଛି ଏଇ ଦରଖାସ୍ତରେ ଯାହା ସବୁ ଲେଖା ହେଇଛି ଏହା ସତ୍ୟ କଥା ଏବଂ ମୋର ଜ୍ଞାନ ଅନୁଯାୟୀ ଏ ଯାହା ଲେଖା ହେଇଛି ମୁଁ ତାକୁ ବିଶ୍ୱାସ କରେ ଯେ ସବୁ ସତ୍ୟ ଏକଥା ମଧ୍ୟ ଲେଖା ହେଇଛି ଏବଂ ଆପଣ ଦସ୍ତଖତ କରିଛନ୍ତି।
ଆଜ୍ଞା।
ତେଣୁ ଯାହା ଲେଖା ହେଇଛି ଯଦି ସତ୍ୟ ସେଥିରେ ଯୋଉ ଡକୁମେଣ୍ଟ ଯୋଉ ଆନେକ୍ସ ହେଇଛି ବା ଦିଆ ହେଇଛି ଯୋଉଥିରେ କି ସେ ଆପେଲାଣ୍ଟ ର ଡେଟ୍ ଅଫ ବାର୍ଥ ଲେଖା ହେଇଛି ସେ ଡକୁମେଣ୍ଟ ରେ ମଧ୍ୟ ଯାହା ଲେଖା ହେଇଛି ଆପଣ ସତ୍ୟ ବୋଲି ସତ୍ୟପାଠ କରିଛନ୍ତି।
ସାର୍ କିଛି ଜାଣିନି ନା ଦେଖିନି, ମୁଁ ଖାଲି ଦସ୍ତଖତ ଆଜ୍ଞା ମତେ କିଛି ଦେଖେ ନା କିଛି ମୁଁ କହିନାହାନ୍ତି।
ଦସ୍ତଖତ କଣ ପାଇଁ ମାରିଲେ?
ଭୁଲ ହେଇଯାଇଛି ସାର୍।
ଆଡଭୋକେଟ୍ସ କ୍ଲର୍କ ର ଯୋଉ ଦାୟିତ୍ୱ ଅଛି ଯିଏ ନାହିଁ ସିଏ ଆଣି ଯାହା ଡକୁମେଣ୍ଟ ଦବ ଏବଂ ଯାହା ଲେଖିବ ତାକୁ ଭେରିଫାଏ କରିକିନି ଆପଣ ଦସ୍ତଖତ କରିଦେବେ ଏବଂ ଆପଣଙ୍କର ସେଇ ଦସ୍ତଖତ ମରା ଯାଇଥିବା ଯୋଉ ପିଟିସନ କୁ ଆଧାର କରି ଆମେ ଲୋକଙ୍କୁ ଜାମିନ ଦେଇ ଦଉଛୁ, ବିଭିନ୍ନ ପ୍ରକାର ରିଲିଫ ଦଉଛୁ। ତ ଏହାର ଦାୟିତ୍ୱ କିଏ ନବ? ବର୍ତ୍ତମାନ ଗୋଟେ ଡକୁମେଣ୍ଟ ବଳରେ ସେ କଣ ଚାହୁଁଥିଲା ଏଇ ଆଦେହରେ ପ୍ରେୟାର କଣ ଅଛି ଜାଣିଛନ୍ତି? ଏ କେସରେ କଣ ହେଇଛି ଜାଣିନାହାନ୍ତି? ଆପଣ ଯୋଉ ଅର୍ଡରଟା ଆମେ ପାସ୍ କରୁଛନ୍ତି ତାକୁ ପଢିଛନ୍ତି? ଯୋଉ ଯାହା ଫଳରେ ଆଜି ଆପଣଙ୍କୁ ଆସିକି ଏଠି ପହଞ୍ଚିବାକୁ ପଡିଲା ସେଟା ପହଞ୍ଚିଛନ୍ତି ପଢିଛନ୍ତି? ଏଇ କେସରେ ତାଲା ନାଁ ହଉଛି ସନାତନ ହିସା ହେଲା। ସିଏ ହତ୍ୟା କରିଥିଲା, ହତ୍ୟା ମୋକଦ୍ଦମାରେ ସେ ବିଚାର ସମ୍ମୁଖୀନ ହେଲା ଏବଂ ତାକୁ ଯୋଉଠି ଟ୍ରାଏଲ କୋର୍ଟ ତାକୁ ଦୋଷୀ ସାବ୍ୟସ୍ତ କରିଥିଲା ଏବଂ ତାକୁ ଆଜୀବନ କାରାଦଣ୍ଡ ଦିଆଯାଇଛି। ଏଇଭଳିଆ ଗୋଟେ ଲୋକ ଏଠି ଅପିଲ ଫାଇଲ କରିଛି ଏବଂ ଅପିଲ ଫାଇଲ କରି କହୁଛି ଯେ ମୋର ବୟସ ଯେତେବେଳେ ଅଫେନ୍ସ ହେଲା ସେତେବେଳେ ମୁଁ ସାବାଳକ ହେଇନଥିଲି ଏବଂ ମୋର ବୟସ ଏଇଆ ଥିଲା ଏବଂ ତାର ବେସିସ୍ ହଉଛି ସ୍କୁଲ ସାର୍ଟିଫିକେଟ ଏବଂ ସେ ଆଡଭୋକେଟ ମହାଶୟ ସେଇ ସାର୍ଟିଫିକେଟ ଯୋଉଟା କି ଆପଣ ଆଫିଡେଭିଟ କରି ଦେଇଛନ୍ତି ତାକୁ ଆଧାର କରି ଆଉ ମାନ୍ୟବର ସୁପ୍ରିମ କୋର୍ଟର ଡିସିସନକୁ ଆଧାର କରି କହିଛନ୍ତି ଯେ ସେ ହତ୍ୟା ଯୋଉ ଦଣ୍ଡ ଯୋଉ ପାଇଛି ତା ଦେହରୁ ତାକୁ ଛାଡି ଦିଆଯାଉ। ତେଣୁ ସେ ସାର୍ଟିଫିକେଟର ଗୁରୁତ୍ୱ କେତେ ବର୍ତ୍ତମାନ ଜାଣିଲେ ନା ନାହିଁ? ତ ଯଦି ସାର୍ଟିଫିକେଟର ଗୁରୁତ୍ୱ ଆପଣ ଜାଣିଲେ ଏବଂ ସେଇଭଳିଆ ଗୋଟେ ସାର୍ଟିଫିକେଟକୁ ଆପଣ ଜାଲ କରିକି ଦେଲେ ଯାହା ଫଳରେ ଗୋଟେ ହତ୍ୟା ମୋକଦ୍ଦମାରେ ଆଜୀବନ କାରାଦଣ୍ଡ ପାଇଥିବା ଲୋକ ମୁକୁଳି ଯିବ, ତାହେଲେ ଆପଣ କୋଉ ପ୍ରକାର ଅପରାଧ କରୁଛନ୍ତି? ଆପଣଙ୍କୁ କଣ ପାଇଁ ଅଦାଲତ ଯୋଉ କଣ୍ଟେମ୍ପ୍ଟ ଅଫ କୋର୍ଟ ପ୍ରୋସିଡିଂ ଅଛି ତା ଦେହରେ କଣ ପାଇଁ ଦଣ୍ଡ ନ ଦିଆଯିବ? ଆପଣ ଆମର ରାଜ୍ୟର ସବୁଠୁ ହାଏଷ୍ଟ କୋର୍ଟ ହାଇକୋର୍ଟର ଆପଣ ଜଣେ ମୋହର ଏବଂ 2017 ମାନେ ଆପଣ 7 ବର୍ଷ ଧରି ଏଠି କ୍ଲର୍କ ହିସାବରେ ଏଠି କାମ କରୁଛନ୍ତି। ତା ଦେହରେ ଆପଣ ନିଶ୍ଚୟ ଜାଣିଥିବେ ଆପଣ କେତେ ଦାୟିତ୍ୱ ଆପଣ ସବୁ ରହିଛି। ଆପଣ ଯୋଉ ବର୍ତ୍ତମାନ ଲେଖିକିନି ଦେଇଛନ୍ତି ଯେ ଆଡଭୋକେଟ୍ସ ପ୍ରିପେୟାର କଲେ ଆଫିଡେଭିଟ ଏବଂ ତାଙ୍କର ଇନଷ୍ଟ୍ରକ୍ସନରେ ଆପଣ ସତ୍ୟ ପାଠରେ ଦସ୍ତଖତ କରିଦେଲେ ଏବଂ ଆପଣଙ୍କର କିଛି ଏଇ ଡକୁମେଣ୍ଟ ବିଷୟରେ ଧାରଣା ନାହିଁ। ଏଇଟା ହଉଛି ଆପଣଙ୍କର ଯୋଉ ସତ୍ୟ ପାଠ କରିଛନ୍ତି ତାର ଏଇଟା କମ୍ପ୍ଲିଟଲି ତା ବିରୁଦ୍ଧରେ ଯାଉଛି। ଆପଣ ସତ୍ୟ ପାଠରେ ଲେଖିଥିଲେ ଯାହା ଲେଖା ହେଇଛି ସବୁ ସତ୍ୟ, ଏ ମୋର ନଲେଜରେ ଅଛି, ଏ ଡକୁମେଣ୍ଟ ସବୁ ସତ୍ୟ, ଏଇଆ କରିକି ଆଫିଡେଭିଟ ଦେଇଛନ୍ତି। ବର୍ତ୍ତମାନ ଯୋଉଟା ଦଉଛନ୍ତି ଏଇଟା କହୁଛନ୍ତି ଯେ ମୋର ସେ ଡକୁମେଣ୍ଟ ବିଷୟରେ କିଛି ଜ୍ଞାନ ନାହିଁ। से एडवोकेट मते कहले एटी दस्तखतटा करदो मु करदेली एटा तो ताठू आउरी माने अलगा प्रकार ही जाउछि ए सर्टिफिकेटटा आपण आनिथिले ना एडवोकेट बाबू आनिथिले
ମୁଁ ସାର୍ କିଛି ଜାଣିନି ମତେ ଖାଲି ଦସ୍ତଖତ କଥା କହିଲେ ମୁଁ ଆଜ୍ଞା ଦସ୍ତଖତ କରିଛି ମୁଁ ସେ ବିଷୟରେ ଆଜ୍ଞା
You are the advocate.
नहीं
Advocate certificate कौन पाए?
सर्टिफिकेट आଜ୍ଞା ତାର ଯୋଉ ପ୍ରିଜନର ଯୋଉ ଉତ୍ତର ଅଛି ତାର ଭିଣେଇ ମତେ ଦେଇଥିଲା ତା ଭିଣେଇ ଦେଇଥିଲା ମତେ ତା ନାଁ ଆଜ୍ଞା ମୁଁ ଜାଣି ମତେ ତା ପୂର୍ବ ରାତିରେ
file an affidavit because of the statement of that your advocate's clerk. You file an affidavit from which source you got that document.
ତାର ଭିଣେଇ ମତେ
we will not leave like that. It is high time that we should check all this type of practice in High Court.
ସେ ଦେଇଥିଲା
ଗୁରୁକ୍ଷେତ୍ର ଆପଣ ଯଦି ଭାବୁଛନ୍ତି ଯିଏ ଯାହା ଦେଇଦବ ଆପଣ ତାକୁ ଆକ୍ସେପ୍ଟ କରିଯିବେ ଏବଂ ସତ୍ୟପାଠ କରିକିନି ଗୋଟେ ଲୋକକୁ କହିବେ ତୁ ଦସ୍ତଖତ ମାରିଦେ ତାକୁ ଫାଇଲ କରିବେ ଏବଂ ଗୋଟେ ଆଜୀବନ କାରାଦଣ୍ଡ ଭୋଗୁଥିବା ଗୋଟେ ଆସାମୀକୁ ଆପଣ ଛଡେଇ ଦେବେ ଏଇଟା ଯଦି ଭାବୁଛନ୍ତି ଏଇ ଟାଇପର ଦାୟିତ୍ୱରେ ଆପଣ କାମ କରିବେ ଏବଂ ଏଇଟା ଠିକ କରୁଛନ୍ତି you file
no
you file an affidavit, then we'll consider from which source you got that certificate and who is that person. We'll go to the root of the matter. Let us see whether whether X and Y had come with you that certificate or somebody else has come. ଆପଣ ସେୟା ଦିଅନ୍ତୁ ଦେଖିକିନି ଆପଣ affidavit ରେ ଦିଅନ୍ତୁ ସେୟା
କୋଉଠି ନ ଜାଣିଛନ୍ତି ଆଜ୍ଞା କୋଉଠି ଗୁଡ୍ ଫେଥ୍ କରାଯିବ ଗୁଡ୍ ଫେଥ୍ଟା କଣ
ସାମ ଦାମ ସାମ ଯିଏ ଯାହା କହିଲା ତ ଆପଣ ଗୁଡ୍ ଫେଥ୍ ରେ କରିଦେବେ ଆଣିକିନି ଆପଣଙ୍କୁ ଯୋଉ ଡକ୍ୟୁମେଣ୍ଟ ଦବ ତାକୁ ଗୁଡ୍ ଫେଥ୍ ଆପଣ କରେଇଦେବେ ଫାଇଲ affidavit then we'll consider ଦେଖନ୍ତୁ in pursuance of the order dated 12/8/2024 why it is not coming back. Mr. Dhanardan Sethi, Advocate's Clerk, has appeared in person and filed the affidavit, wherein he has stated like this, quote from paragraph number 2 to 4. When we put a pertinent question to the deponent as to from which source he got the school's transfer certificate dated 17/8/2019, which is stated to have been issued by headmaster Kathakumpa Primary School, which has been annexed to the interim application in which he has shown the affidavit. The deponent stated that the advocate, Mr. Parshuram Das, who has asked you to sign this? Mr. Nityananda Panda, advocate, asked him to sign the affidavit, and accordingly he has not signed. Accordingly, he has signed the affidavit, and he has no knowledge about the contents of the interim application, nor about the documents which have been annexed to the interim application. What is your name? Nityananda Panda. What is your enrollment number?
2336
Mr. Nityananda Panda, advocate, whose enrollment number is O3036-1999, is present. And when on the basis of the statement made by the advocate's clerk, we made a query to him as to from which source he got the school transfer certificate, which has been annexed to the interim application. He submitted that it was the brother-in-law of the appellant who produced such certificate before him, and accordingly, on good faith, he has annexed the same to the interim application. Let the land advocate, Mr. Nityananda Panda, file an affidavit in that respect, indicating specifically when and who is that person who supplied him the school transfer certificate, which he has annexed, which was annexed to the interim application. Matter will state on 28th of August 2024. 27th, you remain busy. 27th August 2024 at 2 p.m. Nityananda Panda, advocate, shall remain present on that day. Mr. Dhanardan Sethi, advocate's clerk, shall also remain present on that day. Yes.
Whether I may be excused to make a ministerial lordship.
You already.
My name is Muthan Das.
Okay. You remain there on that day.
Your lordship may kindly hear me.
Yes, on that day we'll hear. Yes, next.
On the instruction and
how can it be? How can it you seek your responsibility from this?
Let's see that. Yes, next.
Quickly list passover item number 7.
May I please, your lordship? Well, convicted.
Yes.
Well, convicted under section 302, 307, and 506 of IPC lordship. Convicted for sentence imprisoned for life with fine of 20,000 in default RI for 2 years and more for offense 302 of IPC. Rigorous imprisonment for 10. My lord.
Whether your earlier bail application has been rejected on merit?
No, my lord.
So this is the first bail
application, lordship.
Since when you are in custody?
My lord, custody since 31/8/2013, your lordship, from the date of arrest, your lordship. In between, my lord, the accused person was released on parole bail, your lordship, for some period.
So, what is the
for his good behavior?
What is the custody certificate, Mr.
That is not called. There is a prisoner petition at flag B and D, C and D.
That is for engagement of Vijay Kumar Rover So now I think BJ Robert cannot be
My
used
lord,
in government panel.
Yes. Thereafter, we have filed another work.
So there is no problem there now. So he has to. So Mr. Custody certificate and criminal antecedent,
yes,
if any, can take up this matter on 2nd of September 2024.
Oh, bless you.
Which jail?
Are you that prisoner person ଅଛି ପୁରା
prisoner person ଅଛି
ଆଠଗଡ଼ ଲେଖା ହେଇଛି ହଁ ମଡେଲ କନଭିକ୍ଟ ପ୍ରିଜନ ଆଠଗଡ଼ ହେଲା ଏଟା ରିସେଣ୍ଟ ଇଏ ସେଠି ଥିବ ଲେଖନ୍ତୁ IN number so and so is an application for the land council for the petitioners submitted that the petitioner was taken into judicial custody on 31/8/2013 and thereafter he has been released on parole for some period. Stop. The Land Council for the state seeks for an adjournment to obtain the custody certificate, source to instruction regarding the criminal antecedent from the to the concerned police station. Put up this matter in the week commencing from 2nd September 2024.
Item 11.
Oh, bless you. Bless you.
Item 12. Lord, Mr. Panda is appearing virtually, my lords.
Yes.
Please, your lordship.
Yeah.
Lords, here we are seeking bail, my lords.
and not an year. Yeah.
Item 15. As a workshop. My lord, kindly allow us one more time.
Number 15, paper on adjournment.
Yes, my lord.
Not next week, but
Item 21.
adjournment. From date down to make decision, they wait for you. Yes, Mr. Tripathi.
By 27 item.
27.
Yes.
Item 27.
Please, your six. In this case, my lord.
Just a So in 27, there are one jail criminal appeal is there and another criminal appeal is there, regular.
My lord.
So in both the cases, you are there.
My
So
in criminal appeal, my lord, the appellant is on bail. Other case, they are on in custody.
okay. So from the judgment, it appears page number 13 that as many as 5 persons face trial.
My lord.
So
2 accused are acquitted and 3 are now convicted, my lord.
who have been acquitted?
My lord, that Hathi.
You come to page number 13 of that paper book. Who has been acquitted and who have been found guilty?
Guilty, my lord. Syama Chaudhary, Nivedita Panda.
Syama Chaudhary.
Nivedita Panda. 1 and 2. 1 and 2. They are appearing through jail criminal appeal, my lord.
Just a minute. JCRLA 46 2010 से दी जन appellant अछन.
My lord.
Then another is Suryakant Behra.
Suryakant Behra against Kotak 5.
Yaro JCRLA 442
My lord.
of 2010. And AU Chandra Maharana and Tukuna Maharana alias Hathi kaun hela?
They are acquitted, my lord.
They have been acquitted.
Oh, 3 and 4 acquitted.
My lord. So that 5 Suryakant Behra is now on bail, my lord. Since 2015, my lord.
Okay.
Suryakant Behra.
Suryakant.
5.
Acha, ye sab jail hai. And these jail criminal appeal persons are in custody.
My lord. Syama Chaudhary is the paramour, my lord. The deceased is the husband of Nivedita Panda.
Please let us go to the FIR, then we
My lord.
let us know what is the prosecution. Yes.
They are convicted for the offense under section 302, 201, 511, 34 of IPC, my lord. The second appellant Nivedita Panda is only for 120B.
Now you come to then this relevant portion of the judgment where they have been found guilty for different offenses. and then we'll go to the FIR. This, I think it is
Last page, my lord.
page
40.
running page is 41.
41.
41
40 last-
paragraph 31. Yes.
In the result,
Yeah.
accused persons, namely Chandra Maharana and Tukuna Maharana alias Hathi, are found not guilty of the offences under section 302 and 201, both read with section 34 of IPC, and they are acquitted under section 235 of CRPC. Accused Samu Chaudhary and Suryakanta Behera alias Kotagi are found guilty of the offences punishable under section 302 and 511, 201, both read with section 34 of the IPC, and accused Nivedita Panda found guilty of the offence punishable under section 120B IPC, and they are convicted under section 235 CRPC.
Okay. So please come to the FIR.
Manner.
Before going to the FIR, shall I place something when you will continue? Initially, the date of incident was called at 12/12/2007. Thereafter, the dead body was found in another place on 13/12/2007. And this, thereafter, on 14/1/2008, this FIR was done by the Council of Representatives. 14/1/2008.
Missing report was filed by the councillor, my lord.
Mr. Tripathi, if we come to the FIR, which is page number 45, it appears it was registered on 13/12/2007 under section 302-201, and the occurrence is also on the night of 12 and 13. So, what is the question of that? It was 13/12 is the missing report by the IS. On that basis, case was registered under 302. It's not a. It's all right that FIR is unknown, but it is not a missing report as such. It was treated as FIR and case was registered.
My lord, ମୁଁ କହୁଛି.
Yeah.
On date ଗୁଡାକ ଟିକେ ଖାଲି ଦେଖିବାକୁ ଅଛି. 13/12/2007, the Nuaga police IO has received information that a dead body, half-burnt dead body, is lying near Tamanagati road, my lord.
That is exactly why we say that please place the FIR. Then know that.
My lord.
Come to the FIR page 47.
My lord. এই FIR ରେ ଖାଲି ଯିବା ଆଗରୁ ମୁଁ ଏଠି ଷ୍ଟାର୍ଟ କରୁଛି ଦେଖି ଟିକେ ଫାଷ୍ଟ ପେଜ ଟା ନଜର ପକେଇବା ପାଇଁ ଯେ ଏଇ ଯୋଉ ଇନସିଡେଣ୍ଟ ଟା FIR ରେ ସେ 8:30 ରେ ଇନଫର୍ମେସନ ଆସିଲା କିନ୍ତୁ ଏଇଠି ସେ ଓଭର ରାଇଟିଂ କରି 3:30 PM ରେ ରେଜିଷ୍ଟର୍ଡ କରିଛନ୍ତି 13/12/2007 ଟାଇମ ହେଲା 3:30 PM। नेक्स्ट पेज को आछि आई श्री प्रफुल्ल कुमार पाढ़ी son of Prakash Padhi, Nuaga PS, drawn of plain paper FIR at the spot to the effect that today at about 8:30 AM, on getting a reliable information that one unknown male burnt dead body is lying on Chikiti Tamana Ghata Road near Ghatima Thakurani Temple. On this, I along with staff left for the spot. On reaching at the spot at 9 AM, found that one young male born dead body, aged about 25 to 30 years, dead body is lying by the side of Ghat Road near the bush in naked condition. The wearing apparels
have been burnt
except a little piece of shirt and pant sticking to the body. Bloods are oozing from nose, eye, ear, and mouth. There is injury mark on the upper left eyebrow. The skin have been peeled. Water bubble
have been found. The deceased wore a belt on wrist and a belt on waist and a black color half shoe, of which left shoe is half burnt. The body became blackish. Near the dead body, some drops of blood was found sticking to earth. It is suspected that some unknown culprits, after committing murder elsewhere, threw the dead body near the bush, set fire by pouring petrol or diesel to disappear the evidence. The occurrence might have been taken place on the night of 12 or 13, 2007. As it reveals.
It's all right. Is there any eyewitness to the occurrence? No eyewitness.
No. I know eyewitness, but in the.
What are the circumstantial evidence? Whether it is discussed anywhere in the judgment where these are the circumstances, which page?
My lord.
Oh, that is page number 22, 23. All right. Please come to that. Let us see and then go to the evidence. Let us know that these are the circumstances.
Running page 22, my lord.
22, internal page is 10. And yes, please place it.
He has opined the burn injury to
be.
paragraph arambo korchi.
You come to page paragraph number 11. 11 nouchi te 22 ro sesare tapor next page re circumstance guda ko
If the evidence adduced by the prosecution is found reliable and acceptable, then the following circumstances can be said to have been proved. Though the deceased and accused Nivedita were living together with their children, there was dissension between the two and sometimes between the two.
What is the name of the deceased?
Raghav Ponda.
Raghava Ponda. Okay. This Raghava Ponda is the husband of Nivedita. Okay. Oh, all right. There was dissension between the two, and sometimes it used to be of serious nature. Okay, that is one circumstance. Then
accused Nivedita had intimacy with accused Samo and used to mix with him, which was not liked by the deceased.
Okay.
On 12/12/2007, forenoon, after departure of the deceased to his college, accused Samo and Kotaki had come.
What the deceased was doing?
Lecturer.
Oh.
In City College, Barampur, my
lord.
On 12/12/2007, forenoon, after departure of the deceased to his college, accused Samo and Kotaki had come to deceased's house and had some talk with Nivedita.
Kotaki means that Suryakan Bera.
My lord.
Yes.
March. On the same day in the afternoon, accused Samo had sent PW10 to fetch kerosene for him. PW10 ହଉଛି ତାର ପୁଅ, ତାର ସାନ ପୁଅ deceased, to fetch kerosene for him, and PW10 had in fact brought kerosene and handed it over to accused Samo. At about 4:30 p.m., the deceased returned from his college and took rest for some time. At that time, accused Kotaki came and called PW1 who is the board ଝିଅ. The deceased. According to PW1, the time was 10:30 p.m. Kotaki returned with deceased motorcycle, but the deceased did not come. When asked about the whereabouts of the deceased, accused Kotaki replied that asking him to keep the motorcycle in the house. The deceased went to Hanuman temple. the death of the deceased is found to have occurred on 11:30 p.m. of 12/12/2007. From the same night, accused Samo had been staying in the deceased's house, and when the children used to ask him about their father, his reply was that he would come back soon. He also used to threaten the children not to go outside their house. As stated by the IO on 16/1/2008 night, when he went to the deceased's house to search it, he found accused Samo Chaudhary, accused Nivedita Panda, and 3 children of deceased inside that house, which was then kept bolted from inside. While in custody, accused Samo Chaudhary disclosed that with the help of a Moli Thenga, the deceased was assaulted, and after commission of the crime, the Moli Thenga MO1 was thrown under one culvert near village Ramadihi, and subsequently he led the police to that culvert, where from one Muli Thenga was recovered. Even though Raghav Panda was missing, accused Nivedita, the only major person in the family, did not report about the deceased missing, nor did not take the help of others for days together to find out where the deceased might be. More so, when she herself had asked the deceased to go with Kotaki to see a girl. Thus, my lord,
So these are the circumstances.
my lord.
So if we go circumstance wise, then I think there must be evidence so far as circumstance number 1 is concerned.
My lord.
They were living together and children, and there was dissension between the two. Who has stated about that?
Daughter, first
daughter. That is PW1. Acha. See, and the son has not stated about the quarrel between the parents.
ଭଉଣୀ ଯାହା କହିଛି ତାରି କଥା କହିଛି
Repeat କରିଛନ୍ତି. ଆଚ୍ଛା, ତାମାନେ PW1 ଆଉ PW10 ହଉଛନ୍ତି ଏଇ point ର witness.
ଆଉ ଗୋଟେ ତାର ପୁଅ ଅଛି 9.
PW7 is also there. Relationship was not cordial.
No. She has given letter to the college also, reporting against this person. There is trouble.
As per the evidence of PW7, my lord, they never କହୁଛି ଯେ ତାର uncle ବି ହବ ସିଏ.
So we want to know because that ତାଙ୍କ ଭିତରେ ଯୋଉ dissension କଥାଟା ଉଠୁଛି ଏଠି, ସେଇଟା 1, 10 ଆଉ କିଏ କହୁଛନ୍ତି କହି ନା ଗୁଡା କହିଦିଅନ୍ତୁ. ଆପଣ ଇଏ କରିନାହାନ୍ତି. Circumstantial evidence.
PW7 ବି କହିଛି, never କହିଛି. ଆଉ ଯୋଉ all are saying about this because the PW7 is the relevant thing is there.
Madam, we have to discuss that these are the circumstances. We have to, when we will discuss circumstance wise, that which circumstances have been proved or not proved. Then we have to see whether the chain is complete or not. Right? That is the how the circumstantial evidence case is decided. So we just want to know, since both of you have gone through the brief, so we want to know that on this point that there was dissension, the relevant witnesses, or who are those relevant witnesses?
So far not cordial is concerned.
110 are okay.
113, 7 and 8.
1730. Just 178 and 13.
178.
8 and 13.
8 and 13. Okay. Then you come to the number 2.
Last scene
ଆମେ ଯିବୁ ଆଜ୍ଞା ଗୋଟେ ଗୋଟେ ଆସୁଛୁ ପୁରା ସେଇ number 2 ହଉଛି accused Nivedita had intimacy with accused Samo and used to mix with him, which was not liked by the deceased.
Yes, PW 1, 9 and 10, the daughter and two sons.
Just 1, 9 and 10. Okay. Then the third is on 12/12/2007 afternoon, after departure of deceased to his college, accused Samo and Kotiki, the two male accused persons, they had come to the deceased house and had some talk with Nivedita, and on the same day afternoon, accused Samo sent PW10 to fetch kerosene for him, and PW10 had in fact brought kerosene and handed it over to Samo.
That was PW 1, 9 and 10.
Acha, PW 1, 9 and 10. Next circumstance number 4. At about 4:30 p.m., the deceased returned from his college to Crest. At that time, accused Kotiki came and called him, giving a proposal that they should go to Chikiti to see a girl. At that time, accused Nivedita also induced the deceased to get ready to go with Kotiki. Statement that is okay. Listening to discover statement.
Also PW1 ବି ସେଇଟା କହିଛି
କୋନଟା କହିଛି
ସେଇ ଯୋଉ ବାପା ଶୋଇଥିଲେ ତାଙ୍କୁ ବସିକି ଡାକିଲା ପରେ
ଲାଷ୍ଟ ସିନ୍ ଯାଉଛି ତ ଏଇଟା ଯୋଉ ପ୍ରପୋଜାଲ ଦିବା ଚିକିଟିକୁ ଯିବା ଇଏ ସେଇ ଯୋଉ ଜିନିଷଟା ଏଇଟା ସେ 27 evidence act ର statement ରେ ଅଛି. Now you come to 5. In the evening, deceased and Kotki left the deceased home riding on deceased motorcycle. Some hours thereafter, according to PW1, the time was 10:30. Kotiki returned with deceased motorcycle, but deceased did not come. When asked about whereabouts of the deceased, accused Kotki replied, asking him to keep the motorcycle in the house of the deceased and went to Hanuman temple. Acha. ये evidence के दी one only. Acha.
1, 9, 10.
PW1, 9 and 10. Acha. ठीक है. So death of the deceased is found to have been around 11:30. That is PM report. PW 12.
specific time not given my lord 36 hour obligate
डेड बॉडी टा मिलिला तो
हां
डेड बॉडी टा सी रात्रि रे मिलला ना
सकाळे मिलला 13/12 रे गले 13/12/2007 रे सकाळ 8:30 रे इन्फॉर्मेशन दे जे डेड बॉडी पड़ी छी.
जस्ट अ मिनट. और इन्फॉर्मेशन मिलला सकाळ 8:30 रे
आज्ञा 13 तारीख.
अच्छा. We'll see that. Then next circumstance is from the same night, accused Samo had been staying in the deceased house, and when the children used to ask him about their father, his reply was that he would come back soon, and he also used to threaten the children. 1, 9, 10. Who is 9?
9 is also a son.
ଆଉ ଗୋଟେ ସୂର୍ଯ୍ୟକାନ୍ତ ଗୋଟେ ହଉଛି
ଶ୍ରୀକାନ୍ତ.
Srikanth. PW1 ଗୋଟେ ପୁଅ. Doctor. Then PW9 ଆଉ PW10 ये ଦି ଜଣ ହଉଛନ୍ତି ଦିଟା ପୁଅ. Now you come to the item number 8. That is as stated by the IO on so night when he went to the deceased house to search it, found that Samo Chaudhary, Nivedita and 3 children of the deceased inside the house, which was then kept bolted from inside. It is the evidence of the IO. PW21.
It is para 2 years.
Okay. Then while in custody, Muri Thenga ke PW21 okay. PW21 only. Independent witness hostile agent.
Again.
Achha. Even though last circumstance, even though Raghava Panda was missing, accused Nivedita, the only major person in the family, did not report about accused deceased missing, nor did he take the help of others few days together to find out where the discharge or the conduct action. Okay. motive behind the commission of the crime is the illicit relationship between this wife of the deceased and this someone account.
Shama.
Actually, the wife kept.
My lord, PW7 statement se कहला जे this deceased was earlier married to one Ranjana Bevarta in the year
How age of these children?
1985.
Yes, yes.
This couple has begotten these children.
1985 ରେ ସେ ମ୍ୟାରେଜ କରିଥିଲା ନା ରଞ୍ଜନା ବେବର୍ତା ସେ ସେପାରେଟଲି ରହୁଥିଲେ ବହୁତ ଗୁଡେ କେସ୍ ତାଙ୍କ ଅଗେନ୍ଷ୍ଟ ରେ ଚାଲିଥିଲା ତାପରେ ସେଇ ନିବେଦିତା ପଣ୍ଡା ସହିତ ରହୁଥିଲେ ତାଙ୍କର
Let us go. According to you, three main witnesses in this case are 1, 9 and 10. Let us go to that evidence first. अच्छा जो लास्ट सीन जहाँ संगे अच्छी मोटरसाइकिल जाइथिला तार प्ली कौन से मानुची सेटा ना नहीं मना को डिनर ता नाडा होची कोन
सूर्यकांत बेहरा alias कटक
से टोटल डिनर अच्छा କିଛି ନାହିଁ କହିପାରିବିନି ମିଛ କଥା अच्छा so come to PW1 let us see
I have read requisition of Subhasri Ponda, my lord, case 14. I have read about up to class 6 in Adarsa Sitsu Mandira. The girl appears to be highly intelligent and she answered some of my questions very intelligently. Accused Nivedita Ponda in dog is my own mother. I also knew accused Samo Chaudhary in dog. I also knew no accused Surjakanta Behera Kotaki. I do not know the two other accused persons in dog today. On 12/12/2007, that was a Wednesday in the month of Margashira. My father, who was working as a lecturer in SMIT college, left for the college around 8:30 a.m. After my father left for the college, accused Samo Chaudhary and accused Surjakanta alias Kotaki came to our house and talked to my mother. At that time, I myself, my two brothers Suraj and Srikanta were there in our house.
Suraj and Srikanta PW
9 and 10.
Suraj is PW 9.
Again.
And Srikant is PW 10. Yes.
Accused Samo Chaudhary and Kotaki talked to my mother for some time in a room of our house and then left our house. My father returned from the college to our house around 4:30 p.m. and took rest. When my father was taking rest, accused Samo Chaudhary called my brother Suraj and gave him a bottle to procure kerosene. Around 5 p.m. on 12/12/2007, accused Kotaki came to our house and called my father to go to Chikiti for seeing a girl. My mother also asked my father to get ready as he would be going to see a girl. Accordingly, my father and accused Kotaki left our house for Chikiti in the Hero Honda motorcycle of my father. That night, around 10:30 p.m., for Guruvar Osa, while I was putting jhoti, accused Kotaki arrived in our house and on seeing him, I inquired as to what has happened to my father. And accused Kotaki informed me that my father was at Hanuman temple and he has been instructed by my father to keep the motorcycle of my father in our house. Thereafter, accused Kotaki left our house. Since then, my father did not return to our house.
So this is the last scene evidence.
My
With Samsung.
And accused Samo Chaudhary started living in our house in the night. When I asked accused Samo Chaudhary as to the whereabouts of my father, he was always telling that my father would be returning to the house, and he was also searching for my father. Accused Syama Chaudhary threatened us, saying not to move out of the house or else he would kill us. When accused Syama Chaudhary started coming to our house, my father took exception to that, and since then the relationship between my father and my mother got strained. Police when showed us the photo and the wearing apparels of my father, I could identify those wearing apparels to that my father, and also identified the photo to be that of my father. Crossing
ସେଇଟା ତ ସେଥିପାଇଁ ଇଏରୁ କଲ
dead body କେହି ଦେଖି ନାହାନ୍ତି. Dead body was buried by the police.
ହଁ ଡେଡ୍ ବଡିରୁ ସେ କିଛି ଯାହା ଲେଖା ହେଇଛି wearing apparels burnt
Wearing apparels ବି କିଛି ନଥିଲା, ଯାହା ଏଫଆଇଆର ରେ ଲେଖା ହଉଛି ଡେଡ୍ ବଡି ଓପନ ଥିଲା, ନେକେଡ୍ ଡେଡ୍ ବଡି ପଡିଥିଲା. ସେଇ ଯୋଉ ଟିକେ ଟିକେ ଲାଗିଥିଲା ସେଇଗୁଡାକ ସେ ଦେଖିକିରି
burnt dead body ଏଜେଡ୍ ଅବଶ୍ୟ ପିଏମ୍ ହେଇଥିବ ନା?
ଆଜ୍ଞା ହେଇଛି.
ହଁ ନାଇଁ ଆଇଡେଣ୍ଟିଫିକେସନ ସିଏ ଝିଅ ଯାହା କହୁଛି ଏଇ ଯୋଉ PW1 ସିଏ ମାନେ ଡ୍ରେସ୍ ରୁ ଚିହ୍ନିଛି ନଟ୍ ଦ୍ୟାଟ୍
ଫିଜିକାଲ ବଡି କିଛି ନାହିଁ,
ହଁ ବଡି କିଛି ନାହିଁ, ଡ୍ରେସ୍ ରୁ ଯାହା ଚିହ୍ନିଛି ଆଇଡେଣ୍ଟିଫାଇଡ୍ ଟୁ ବି ଦି ଫଟୋ ଅଫ୍ ମାଇ ଫାଦର.
କର୍ପସ୍ ୱାଜ ବର୍ଣ୍ଟ.
ହଁ କର୍ପସ୍ ୱାଜ ବର୍ଣ୍ଟ. ଆଚ୍ଛା ଦେନ୍
ଏଗୁଡା ସବୁ ଫଟୋଗ୍ରାଫ, ଏଗୁଡା କିଛି ଆପରେଲ ଶୋ କରିନାହାନ୍ତି. ପୋଲିସ ର ଷ୍ଟେଟମେଣ୍ଟ ରେ ଅଛି ଯେ ଆଉ କିଛି ସେ ରଖିନି, ସେ କେବଳ ସେ ଯୋଉ ଫଟୋ ବାକି ଯାହା ସେ ମାନେ କେମିକାଲ ଏକ୍ସାମିନେସନ କୁ ପଠେଇଥିଲି ସେତିକି, ନହେଲେ ଆଉ ସେ କିଛି ଶୋ କରିନାହାନ୍ତି ଫିଜିକାଲି କୌଣସି ତାଙ୍କର ଫ୍ୟାମିଲି ମେମ୍ବର୍ସ କୁ. ଏଗୁଡା ସବୁ ସେ ଫଟୋଗ୍ରାଫ ଦେଖିକି ହିଁ କହୁଛନ୍ତି.
ନାଇଁ ବଡିର ତ କିଛି ନଥିଲା ଆପଣ ଯାହା କହୁଛନ୍ତି, ଯେ ବଡିଟା ପୁରା ପୋଡି ଯାଇଥିଲା, ଖାଲି ମାନେ ଡ୍ରେସ୍ ର କିଛି ଅଂଶ ବୋଧେ ଥିଲା,
ଗୋଟେ ଫାଳ ଚପଲର
ହଁ ଆଉ କଣ କିଛି ପାର୍ଟ ଥିବ ଯୋଉଥିରୁ, ବଟ୍ ଏଇ ୱିଟନେସ୍ ଟା ଆଟଲିଷ୍ଟ ଜଣା ପଡୁଛି ଆଇଡେଣ୍ଟିଫିକେସନ ଦ୍ୱାରା ଫଟୋଗ୍ରାଫ ରୁ ସେ କରିଛି ଏବଂ ୱେରିଂ ଆପେରାଲ୍ସ ଦେଖିକି ଚିହ୍ନୁଛି. All right, you continue.
Cross examination for accused Syama Chaudhary. I left my studies after the missing of my father in December 2007. I was a student of Adarsha Sishu Vidya Mandira, which situated at Nilakantha Nagar in Barampur town. I left my studies when I was in class 6. I cannot say the name of the principal or Acharya of our school who was there in the year 2007. I also cannot tell the name of the class teacher of mine in the year 2007. I cannot say the festivals which we celebrated in the month of December 2007. I came to know accused Syama Chaudhary only when he started visiting our house 2 years back, and prior to that I did not know him at all. I cannot say the full name of accused Kotaki. I came to know also accused Kotaki 1 month prior to the missing of my brother, as my father was to see a girl whom he would marry. My father in all might have talked to accused Kotaki on 2 to 3 occasions prior to the occurrence. I used to go to my school at 10 o'clock and returns from school by 5 p.m. On 12/12/2007, I had not gone to the school as I had left my studies for 1 year by then. My two brothers, namely Suraj and Shrikant, had also stopped going to school by 12/12/2007. And my two brothers had stopped going to school because of the family dissension that arose between my mother and my father. And also my mother had left for Nabarangpur and stayed in the house of my Mausi along with us because of such family dissension. Accused Syama Chaudhary had taken us to Nabarangpur. My father had two other brothers. The house in which we were living at the time of occurrence is our ancestral house. For that ancestral house, my father and my Badabba, Rajiv Panda, used to quarrel. PW2, my lord, say Rajiv Panda. He is a witness. The first wife of my father, whose name I do not know, is alive and is staying in Barampur. I have heard from my mother that a son was born out of the wedlock of my father, though his father
Passed away.
through his past wife. I know that my stepmother was litigations with my father, and there were many cases. In old Barampur, my grandfather had another house, and my father had also occupied that house. I have not seen any photo of my father and my mother, Nivedita, to show that they are legally married. I cannot say if there was a divorce between my father and his first wife. 1 month after the missing of my father, I was examined by police, and that was the only occasion when police examined me.
The deceased भी आगू बाहर निकला, ये भी बाहर निकला. माने that's you accused you lady टा.
नहीं ସିଏ ବାହା ହେଇନଥିଲା.
लेडी बाहर नहीं.
नहीं
माने मुको जी निवेदिता का.
निवेदिता
निवेदिता बाहर निकली, ये बाहर के she had
ନିବେଦିତା ଇଜ କଙ୍କୁବାଇନ ମାଇ ଲର୍ଡ. ସେ ଫାଷ୍ଟ ୱାଇଫ ଟା ଗଲା ଭାରି ପରେ ସେ ଅଛି ତା ସାଙ୍ଗରେ. ସେ ଲିଗାଲି ମ୍ୟାରେଜ ହେଇନି, ତେଣୁ ସେ କହିପାରୁନି ତାର ବାପା ମାଙ୍କର ଏକା ଏକା ଫଟୋ ଏକାଠି ଫଟୋ.
आर वाइफ टे थिला गोटे वाइफ. ठीक है. Yes, next.
1 month after the missing of my father, I was examined by police, and that was the only occasion when police examined me in this case. I cannot say the date when police examined me in this case. It is not a fact that I did not state before police that while my father was taking rest after returning from college at 4:30 p.m., accused Sama Chaudhary came to our house and called my brother Suraj and hand over him a bottle to procure kerosene. Police produced me before a magistrate for recording my statement. It is a fact that I had stated before the magistrate that accused Sama Chaudhary had sent my younger brother Suresh Ponda by Suresh Ponda by handing him a bottle to fetch kerosene. It is not a fact that I have not stated before police that on 12/12/2007, while my father was taking rest after returning from the college at 4:30 p.m., accused Samo came to our house and called my brother Suraj and hand over a bottle to fetch kerosene. It is not a fact that I did not state before police that accused Kotoki came to our house and in the motorcycle of my father they left for Chikiti to see a girl. It is not a fact that I did not state before police that on 12/12/2007 night around 10:30 p.m.
କିଛି କହିନି police ପାଖରେ first time କୋଉଠି?
it is not a fact.
It's not a fact.
ଏଗୁଡାକ ସବୁ ଏଗୁଡା ସେ I have not stated.
That means he claimed that I have stated. So whether the defense has proved through the IO that in fact he has not stated his. Otherwise this is meaningless, this confrontation. Where is that? Who is that IO? 21.
ତାର 164 statement ଟା ଲାଗିଛି 193 page ରେ.
Just let us go to
192.
PW21 is the IO. Where this confrontation about the previous statement has been proved. Because not only it is to be confronted, but it is to be proved through the IO. So if it is not done, then this is irrelevant. This confrontation becomes. So that is why. Okay, you come to paragraph number 34, page 185.
I had examined Subhasri Panda, PW1, the daughter of Raghav Panda. PW1 had not stated before me that on 12/12/2007, her father, after returning from the college around 4:30 p.m., while taking rest, accused Samo Chowdhury came and sent her brother to fetch kerosene. PW1 has not specifically stated before me that her father and Kotaki proceeded in his motorcycle to Chikiti to see a girl. PW1 has also not stated before me that when accused Kotaki came to their house on 12/12/2007 at 10:30 p.m., she asked him about the whereabouts of her father. PW1 has also not stated before me that that accused Shama Chaudhary threatened to kill them if they go out of the house. PW1 has also not stated before me that after missing of her father, accused Shama Chaudhary came and stayed in their house.
Okay, this has been proved. Let us go to that statement because 164 କୋଉଠି ଅଛି ଆପଣ କହୁଥିଲେ
1911 to 193
193 କୁ ପଳେଇ ଆସନ୍ତୁ ପଢ଼ନ୍ତୁ ସେଟା ଟିକେ
ଏଟା paragraph 1 ଟା
ଛାଡି ଦିଅନ୍ତୁ ସେଇ ପଳେଇ ଆସନ୍ତୁ ଓଡିଆ
ଆଜି ମୁଁ ସ୍ୱଇଚ୍ଛା
What is your school name? From the
ଆଜି ମୁଁ ସ୍ୱଇଚ୍ଛାରେ
ଆଜ୍ଞା ଆଜି ମୁଁ ସ୍ୱଇଚ୍ଛାରେ କାହା ଦ୍ୱାରା କିମ୍ବା କୌଣସି ଦ୍ରବ୍ୟ ଦ୍ୱାରା ପ୍ରଭାବିତ ନ ହୋଇ ନିର୍ଭୀକ ଭାବରେ ମୁକ୍ତ କଣ୍ଠରେ ବୟାନ ଦେଉଅଛି କି ଘଟଣାଟି 12/12/2007 ପ୍ରାୟ 5ଟା କି 6ଟା ସନ୍ଧ୍ୟା ସମୟ ଆମ ଘରେ ଘଟିଅଛି। ଜଣେ ବ୍ୟକ୍ତି ନାମ କଟକୀ ଆମ ଘରକୁ ଆସିଲେ। ସେ ଆମ ବାପାଙ୍କୁ ଡାକି ଝିଅ ଦେଖିବାକୁ ଅନୁରୋଧ କଲେ। ସେ ଚିକିଟି ଯିବା ପାଇଁ କହିଥିଲେ। ମୋ ବାପା କଲେଜରେ ଲେକ୍ଚର ଅଟନ୍ତି। ସେ ଆସି ଘରେ ରେଷ୍ଟ ନେଉଥିଲେ। ମୋ ବାପା କଟକୀ ସହିତ ମୋଟର ସାଇକେଲରେ ଚିକିଟି ଗ୍ରାମ ଆଡକୁ ଝିଅ ଦେଖିବା ପାଇଁ ଗଲେ। କଟକୀ ମୋଟର ସାଇକେଲ ପଛରେ ବସିଥିଲେ। ବାପା ଗଲାବେଳେ ବାପାଙ୍କୁ ମୁଁ ଟାଟା କଲି। ସେଇଦିନ ରାତିରେ ଗୁରୁବାରେ ଘରେ ଛୁଟି ଦେଉଥିବା ସମୟରେ ରାତି ପ୍ରାୟ 9ଟା କି 10ଟା ସମୟ କଟକୀ ଅଙ୍କଲ ଆସି କହିଲେ ତୁମ ବାପା ହନୁମାନ ମନ୍ଦିର ଆଗରେ ରହିଗଲେ। କଟକୀ ଅଙ୍କଲ ବାପାଙ୍କ ଗାଡି ଆଣି ଆମ ଘରେ ରଖିଦେଲେ। ମୋ ବାପା ଆଉ ଘରକୁ ଫେରି ନାହାନ୍ତି। କଟକୀ ଅଙ୍କଲ ଆମ ଘରକୁ ପ୍ରାୟ 2 ଥର ଆସିଛନ୍ତି ଏବଂ ବାପା ଆସିଛନ୍ତି କି ନାହିଁ ପଚାରିଛନ୍ତି। ବାପା ଗଲା ପରଦିନ ଠାରୁ ଶ୍ୟାମ ଅଙ୍କଲ ଆମ ଘରକୁ ଯିବା ଆସିବା କରୁଛନ୍ତି ଓ ରାତିରେ ରହୁଛନ୍ତି। ଶ୍ୟାମ ଅଙ୍କଲ ଆସି ଆମ ମାମାଙ୍କୁ ଙ୍କ ସହିତ ରାତିରେ ଏକ ରୁମରେ ଶୋଉଛନ୍ତି। ଆଗରୁ ମଧ୍ୟ ଶ୍ୟାମ ଅଙ୍କଲ ମଧ୍ୟ ଆମ ଘରକୁ ଆସନ୍ତି। ସେ ବାପା ନଥିଲା ବେଳେ ଆସନ୍ତି। ମାମାଙ୍କ ସହିତ କବାଟ ଦେଇ କଥାବାର୍ତ୍ତା ହୁଅନ୍ତି। ବାପା ଓ ଶ୍ୟାମ ଅଙ୍କଲଙ୍କ ମଧ୍ୟରେ ଗଣ୍ଡଗୋଳ ହୋଇଥିଲା। ଆମ ମା କଟକୀ ଅଙ୍କଲ ଆସିଛନ୍ତି ତାଙ୍କ ସହିତ ଯା ବୋଲି କହିଥିଲେ। ମୁଁ ଜାଣିଲି ଯେ ମୋ ବାପା ମରିଯାଇଛନ୍ତି। ପୋଲିସ ମତେ ବାପାଙ୍କ ପେଣ୍ଟ ସାର୍ଟ ଜୋତା ଚଷମା ଓ ଫଟୋ ଦେଖାଇଥିଲେ। ଏହା ମୋ ବାପାଙ୍କର ବୋଲି ଚିହ୍ନିଲି। ଶ୍ୟାମ ଅଙ୍କଲ ମୋ ସାନ ଭାଇକୁ ସୁରେଶ ପଣ୍ଡା ବୋତଲ ଦେଇ କିରୋସିନ ପାଇଁ ପଠାଇଥିଲେ। ସେ କିରୋସିନ ଆଣି ଶ୍ୟାମ ଅଙ୍କଲକୁ ଦେଇଥିଲା। ତାପରେ ଶ୍ୟାମ ଅଙ୍କଲ ଯାଇଥିଲେ। ଶ୍ୟାମ ଅଙ୍କଲ ମୋତେ ଓ ମୋର ମାମାଙ୍କୁ ଧମକେଇ ଦେଲେ। କହିଲେ ଏଠାରୁ ବାହାରିଲେ ସମସ୍ତଙ୍କୁ ମାରିଦେବି। ଶ୍ୟାମ ମୋତେ ଓ ମୋ ଭାଇକୁ ବାଡିରେ ବାଡେଇଥିଲେ। ମୋ ଦେହ ଫୁଲି ଯାଇଥିଲା। ଡାକ୍ତର ଦେଖାଇବାକୁ ଛାଡିଲେ ନାହିଁ। ମୋତେ କେହି ଟ୍ୟୁଟର କରିନାହାନ୍ତି। ମୁଁ ଯାହା ଯାହା ସତ କଥା ତାହା ହିଁ କହୁଛି।
So it is almost in consonance with the evidence. Perhaps in 161 some 161 by the way ଟିକେ ଦେଖିବ 161 କେମିତି ଆସିଲା ତା ନାଁଟା ହଉଛି
ଶୁଭଶ୍ରୀ ପଣ୍ଡା।
ଶୁଭଶ୍ରୀ ଶୁଭଶ୍ରୀ ପଣ୍ଡା have you got that statement with you? ପଢିଲେ ଏଇଟା ପ୍ରିଣ୍ଟ କାଢିକି ମିଷ୍ଟର ତ୍ରିପାଠୀ ଗୋଟେ ପେଜ ଦିଟା କପି କରିଦିଅନ୍ତୁ ଦି ଜଣ ଦିଟା
ମୋର ନାମ କୁମାରୀ ଶୁଭଶ୍ରୀ ପଣ୍ଡା, ବୟସ 14 ବର୍ଷ, ପିତା ରାଘବ ପଣ୍ଡା, ପୁରୁଣା ବ୍ରହ୍ମପୁର ସାହି ବ୍ରହ୍ମପୁର। ଆଜି 12/1/2008 ଥାନା ନୂଆଗାଁ ଥାନା ଇନ୍ସପେକ୍ଟର ବାବୁଙ୍କୁ ଦେବା ଜମାନବନ୍ଦୀ ହେଇକି ଯେ ଗତ ମାର୍ଗଶିର ମାସ ତୃତୀୟ ପାଳି ବୁଧବାର ଦିନ ଅର୍ଥାତ୍ 12/12/2007 ସନ୍ଧ୍ୟା ପ୍ରାୟ 5 ଘଣ୍ଟା ସମୟ ହେବ ଜଣେ ଲୋକ ଯାହାକୁ କଟକୀ ବୋଲି ଜାଣିଛି ସେ ଆମ ଘରକୁ ଆସି ଆମ ବାପା ଯିଏ SMIT ରେ ଲେକ୍ଚର ଅଛନ୍ତି କଲେଜରୁ 5ଟା ବେଳେ ଆସି ରେଷ୍ଟ ନେଉଥିଲେ। ତାଙ୍କୁ ମା ଡାକି କହିଲେ କଟକୀ ଭାଇ ଆସିଛନ୍ତି, ଚିକିଟିରେ ଝିଅ ଦେଖିବାକୁ ଯିବାକୁ ଜଗିଛନ୍ତି। ଏହା ଶୁଣି ବାପା ଆମ ମୋଟର ସାଇକେଲ କାଢିଲେ, କଟକୀ ଅଙ୍କଲ ପଛରେ ବସିଲେ। ବାପା ଗଲାବେଳେ ମୁଁ ଟାଟା କଲି। ସେଇଦିନ ରାତ୍ର ପ୍ରାୟ 10ଟା-11ଟା ସମୟ ହେବ। ସକାଳୁ ଗୁରୁବାର ଥିବାରୁ ମୁଁ ଓ ମା ଝୋଟି ପକାଉଥିଲୁ। ସେତେବେଳେ କଟକୀ ଅଙ୍କଲ ଆସି କହିଲେ ତୁମ ବାପା ହନୁମାନ ମନ୍ଦିର ଆଗରେ ରହିଗଲେ ଓ ଗାଡି ଘରେ ଦେଇଦିଅ ବୋଲି କହିଲେ। ତାପରେ ବାପା ଘରକୁ ଫେରି ନାହାନ୍ତି। ତା ପରଦିନଠୁ ଶ୍ୟାମ ଅଙ୍କଲ ଘରକୁ ଆସି ସବୁଦିନ ଆଜି ପର୍ଯ୍ୟନ୍ତ ଯିବା ଆସିବା କରି ରାତ୍ର ରହୁଛନ୍ତି। ଶ୍ୟାମ ଅଙ୍କଲ ଓ ମା ଗୋଟିଏ ରୁମରେ ରହୁଛନ୍ତି। ମୁଁ ଅଙ୍କଲକୁ ବାପା କୁଆଡେ ଗଲେ ବୋଲି ପଚାରିବାରୁ କୁଆଡେ ଯାଇଛନ୍ତି ଆସିବେ, ମୁଁ ଖୋଜାଖୋଜି କରୁଛି। ସେ ଦିନ ପରେ କଟକୀ ଅଙ୍କଲ ମଧ୍ୟ 2 ଥର ଆସି ବାପା ଆସିଲେ କି ବୋଲି ପଚାରିଛନ୍ତି। ଆଗରୁ ମୋ ବାପା ଘରେ ନଥିଲା ବେଳେ ଶ୍ୟାମ ଅଙ୍କଲ ଲୁଚିକି ଆସି ଘର ମଝି କବାଟ ଦେଇ ମାଙ୍କ ସହିତ ବେଶୀ ସମୟ ରହନ୍ତି। ଏଥିପାଇଁ ବାପା ଓ ଶ୍ୟାମ ଅଙ୍କଲଙ୍କ ମଧ୍ୟରେ ଗଣ୍ଡଗୋଳ ବି ହୋଇଛି। ମା ବାପାଙ୍କୁ କହନ୍ତି ତୁମେ ଆଉ ଗୋଟିଏ ମୁଁ ତୁମ ପାଖରେ ରହିବିନି। ଆଜି ଆପଣ ଆଣିଥିବା ଫଟୋ ଦେଖି ସେଇ ଫଟୋ ବାପାଙ୍କର ବୋଲି ଜାଣିଲି ଏବଂ ଦେଖେଇଥିବା ପ୍ୟାଣ୍ଟ ସାର୍ଟ ଜୋତା ଓ ଚଷମା ମୋ ବାପାଙ୍କର ବୋଲି ଚିହ୍ନିଲି। ମୋ ବାପାଙ୍କ ସାଙ୍ଗରେ ଏଇ ବିଷୟ ନେଇ ଗଣ୍ଡଗୋଳ କରେ। ମୋ ବାପା ମାଙ୍କ ସାଙ୍ଗରେ ଏଇ ବିଷୟରେ ନେଇ ଗଣ୍ଡଗୋଳ କରେ।
ସେ କିରୋସିନ କଥାଟା ଅବଶ୍ୟ ନାହିଁ, ସେ ଯୋଉ ତାକୁ ପଠେଇଥିଲା ସେଇଟା ନାହିଁ। ବାକି ମେନ୍ କଥା ହଉଛି ଆଉ ଯୋଉ ଲାସିନଟା ଅଛି ଏବଂ ଆସିକି କହିଲା ହନୁମାନ ମନ୍ଦିରରେ ରହିଗଲା, ଦ୍ୟାଟ ଇଜ ଅଲସୋ ଦେୟାର। ତାପରେ ଏମାନଙ୍କ ଭିତରେ ଯୋଉ ରିଲେସନସିପ ସେଇଟା ଆଉ ଗୋଟେ କଥା ହଉଛି ଏଇ ଯୋଉ ଚିଫ ରେ ଯୋଉଟା କହିଲା, ଇଟ ଇଜ ନଟ୍ ଦ୍ୟାଟ ଓନ୍ଲି କି ତାକୁ ଆଣି କଣ ସେ ଦେଖେଇଲା କହୁଛି ଫଟୋ ଏଠି ଏଗୁଡାକ କ୍ଲାରିଫାଇ କରୁଛି। ଚଷମା ବି ଦେଖେଇଛନ୍ତି ତାକୁ, ଚଷମା ସାର୍ଟ ଜୋତା।
ଆଜି ଆପଣ ଫଟୋ ଦେଖି ସେ ଫଟୋରେ ବାପାଙ୍କ ବୋଲି ଜାଣିଲି, ଦେଖାଇଥିବା ପ୍ୟାଣ୍ଟ ସାର୍ଟ ଜୋତା ଚଷମା।
ସବୁ
ଏଫଆଇଆର ତ କିଛି ଲୁଗାପଟା ନଥିଲା ବୋଲି ଲେଖୁଛି। ପୋଲିସ ଯୋଉ ଏଫଆଇଆର ଟା ଲେଖିଛି
ତାର ସିଜର ଲିଷ୍ଟ ଥିବ ନା,
ସିଜର
we'll see that, we'll go to that about that seizure list what is there and
inquest is there,
inquest they ଜଣା ପଡୁଛି ତାର
अच्छी बेल्ट पिंधिथिबा बेल्ट पैंट सब अच्छी लागिथाई सार्ट किछि खंड
Deceased date of birth is statement of the IO my lord से जो सर्विस बुक रू सब सीज करचंदी तांका डेट ऑफ बर्थ होची 12/4/1957 କିନ୍ତୁ ଏଇ ଯୋଉ ଡକ୍ଟରଙ୍କ ରିପୋର୍ଟ ଆଉ ସେ ଏଫଆଇଆର ରେ ସେ ଲେଖୁଛନ୍ତି ଏଇ ଲୋକଟା ହଉଛି 25 ରୁ 30 ବର୍ଷର ଲୋକଟା
ଫଟୋଗ୍ରାଫ ନିଆହେଇନି ଫଟୋଗ୍ରାଫ
ଫଟୋଗ୍ରାଫ ନେଇଛନ୍ତି ଡେଡ ବଡି ଟା ତ ପୋଡି ଯାଇଛି ନା ପୁରା କଳା ହେଇଯାଇଛି ଲେଖିଛି ଏଫଆଇଆର ରେ
ଡେଡ୍ ବଡି କମ୍ପ୍ଲିଟଲି ଚାର୍ଡ
ଶୁଣନ୍ତୁ ଏଇ ଯୋଉ ଗୁଡାକ ଦେଖିଛନ୍ତି ସେମାନେ ଯଦି ଚଷମା ରହିଲା ପ୍ୟାଣ୍ଟ ସାର୍ଟ ଜୋତା ଚଷମା ତା ସହିତ ଫଟୋ ଆସିଲା ତେଣୁ identification so is it your case that the body which was that
Yes.
was not of the deceased
my lord
huh
my lord
କିଏ ନେଇକି
ପ୍ଲି ରେ ଅଛି ତାର
ସବୁ ତ ନାହିଁ ଆଉ କଣ ଖାଲି ମିଛ କଥା ଛଡା ଆଉ କିଛି
confidently after the incident night he is staying with that lady.
Sama is staying with that lady.
No, that indicates that he was dead sure that this man will not return.
Also the dead body ର DNA test ବି ହେଇନି କିଛି ବି କରିନାହାନ୍ତି ଖାଲି ସେତିକି କରିକି
we have not gone through all those things but question of identification ମାନେ ଫାଷ୍ଟ ଇମ୍ପ୍ରେସନ ଭାବୁଥିଲୁ ଯେ ବୋଧେ ଖାଲି ଗୋଟେ କଣ କପଡା ଆଣି ବୋଧେ ଦେଖେଇଛନ୍ତି କୋଡା ବଟ୍ ଏତେ ଗୁଡାକ ଜିନିଷ ଯଦି ଦେଖେଇଥିବେ ତା ଦେହରୁ ଜୋତା ଚଷମା ଏ ସବୁ ମିଶିକିନି then whether identification is possible particularly when you have not disputed it PM Dr. K PW
burnt remnants of maroon color underwear, blue color banyan, green and white stripes. A remnant of strands, scared thread, sacred thread, strand of sacred thread.
Khadim rubber half suit पूरा ଭଲ ଅଛି ଜଣା ପଡୁଛି left side ରୁ ଟିକେ ଇଏ ହେଇଛି melted partially
remnants of leather belt were found on the body surface of the deceased. Body surface of the
smell of kerosene
was faintly coming from the body surface. Superficial bone with blackening and charring. Char charring at places covering almost entire body. तमाने किछि जगह रे deep wound ହେଇଛି ଚାର୍ଡ ଯୋଉଟା ହେଇଯାଇଛି ଜଳି ଯାଇଛି ପୁରା ବ୍ଲିଷ୍ଟର୍ସ ଅଛି
এই ফটোগ্রাফস টিও দেখি অরিজিনাল দেখে स्कॉल रे देखंदु ऑन डिस्ट्रक्शन ने जोड़ा मारचंदी पेज 131 रे स्कॉल टा डिप्रेस्ड फ्रैक्चर ऑफ स्कॉल अछि त साइज भी देइछंती हैला तेनु मुंडरे माडा ହେଇଛି तापर फ्रैक्चर ହେଇଛି ଏବଂ ଅନ୍ୟାନ୍ୟ इंजुरी गुडा ମଧ୍ୟ ଅଛି लैसेटेड वुंड ଅଛି राइट मैंडिबल रे गुडा सब ଅଛି सेहि पई वी हैज ओपाइन ता परे पोडा ହେଇଛି याकू ये से माडा हला परे Define the base of this call. Injury number 1 is found to be fractured, starting from left side, extending up to the right side, multiple fracture. So virtually, if we see the time gap between the last scene and that dead body that was recovered, that was not even 12 hours. କାରଣ ରାତିରେ ସେମାନେ ଗଲେ 10ଟା ଖଣ୍ଡେ ବେଳକୁ ଯାଇଛନ୍ତି ଫେରିଟା 10ଟା ଏବଂ ସକାଳ 8ଟା କେତେରେ ଡେଡ୍ ବଡି ମିଳିଲା ଖବର ଯାଇକି ପହଞ୍ଚିଲା। ତେଣୁ ଅବଶ୍ୟ ସେତେବେଳକୁ ଏମାନେ ଫ୍ୟାମିଲି ମେମ୍ବର୍ସ ଜାଣିନାହାନ୍ତି ଯେ ଏମିତି ଗୋଟେ ବଡି ମିଳିଗଲାଣି ଯୋଉଟା ପରେ ମେ ବି ସେମାନେ କଣ ମିସିଂ ରିପୋର୍ଟ ଦେଲେ।
ଆଜ୍ଞା କାଉନସିଲର ଯୋଉ PW 17 ଯେ ସେ ଦେଇଛି ଗୋଟେ ଯୋଉ ଫଟୋଗ୍ରାଫ ସର୍କୁଲେଟ ହେଲା ତାରି ସେ ଫଟୋଗ୍ରାଫ କୁ ଦେଖିଲା ପରେ ସେ ଗୋଟେ ମିସିଂ ରିପୋର୍ଟ ଦେଲା ଯେ ଆମ ଏରିଆରୁ ଗୋଟେ ଲୋକଟେ 20 ଦିନ ହେଲାଣି ମିସିଂ ହେଇଯାଇଛି ବୋଲି। ଆଜ୍ଞା ତାପରେ ସେ ଆସିକି
ସେଠୁ ଇଏ ଆସିଛି।
Para 7 of PW 12. Weapon used.
Sending the weapon of offense wouldn't stick as to whether the antemortem which are detected.
At the instance of that,
it was detected on the person of the deceased. Could have been caused by that weapon.
जो leading to discovery କହିଛି
जो temporal region में जो fracture गुड़ा कहला occipital region को ଆଉ mandible region में जो सब lacerated wound थिला that was caused by that lathi which was recovered at the instance of that. That is the evidence.
ସେଟା ମାସେ ପରେ ଗୋଟେ କରିଛି ତାର leading to discovery ଟା ସେଇଟା ବି ସେ କୋର୍ଟ କୁ ଦେଖେଇ ନାହାନ୍ତି କି କେମିକାଲ ଏକ୍ସାମିନେସନ ପାଇଁ ପଠେଇ ନାହାନ୍ତି ଖାଲି ଯାହା ଡେମୋ ନାଇଁ ସାର୍ କୋର୍ଟ କୁ ଦେଇ ନାହାନ୍ତି ଏଟା କେବଳ ସେଇ ମେଡିକାଲ ଡକ୍ଟର କୁ ଦେଇଛନ୍ତି ଆଉ ସେ ଏଇ wound ଟା ତା ଦେହରେ ହେଇଛି କି ନାଇଁ ବୋଲି ସେଇଟାକୁ ସେ କ୍ୱେରି କରିଛନ୍ତି। ଏଇଟା ସିଜର ରେ ଦେଇଛି ଗୋଟେ
କିଏ ମାର୍କ କଲା
ସେ ଡକ୍ଟର ସାର୍ ଡକ୍ଟର MO1 କରିଛନ୍ତି ଏଇଠି ଲେଖିଛନ୍ତି ଲାଷ୍ଟ ଏଇ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ ଲେଖିଛନ୍ତି।
This is that weapon of offense sent to me by police which I examined marked MO1. So he has so the stick that was given is face is clear. Face is clear.
No, आराम से चीनी पड़ेगा। Just see that it's not.
Face is clear. Body charred and some portion of it. ମାନେ ତ ପୋଡ଼ିବାଲି ଚେଷ୍ଟା କରିଛନ୍ତି ହେଇନି ଯୋଉ ଜାଗାରେ ଡିପ୍ wound ହେଇଛି ସେଠି ପୋଡ଼ି ଯାଇଛି otherwise
it's not that ଯେତେବେଳେ ଡାଉଟ୍ ହେଲା ଯେ ରିଅଲ ଜିନିଷଟାକୁ ଦେଖିଦେଲେ ଜଣା ପଡିବ। ତେଣୁ ଯୋଉ
DNA ଏଇଠି ଆଉ କିଛି ହବା
DNA ହେଇନି
ଦରକାର ନାହିଁ
ବଡି ଦେଖାଯାଉଛି clearly. See all these photographs, face, everything is clear. This has been marked as exhibits.
कौन से बैठे हो देखना
You are not fully ready or what?
No.
He is scared of the photograph. Look at this.
Once you don't be scared. Criminal case ନ ଦେଖିଲେ ଆପଣ ଜାଣିପାରିବେନି ଆପଣ ଜିନିଷଟା ଏଭିଡେନ୍ସ କୋଉ ଟାଇପର ଆସୁଥିଲା। Now once you see that you can say that.
So we had an impression that probably only the remnants of this cloth and speck is there. The entire body is there.
Easily it can black.
So, madam, your submission that was you are advancing that whose dead body nobody knows. So it cannot be said that the body is of that of the father of this one so and so. Now that cannot be accepted. So now the other circumstances is to be seen, and we'll take on this matter next week. Continue this matter.
ଆର ୱିକରେ ଟିକେ ଦିଲ୍ଲୀ ଯିବାର ଅଛି ବାପାଙ୍କ ଦେହଟା ଟିକେ ଅସୁସ୍ଥ ଅଛି।
Second.
Next.
All right. Representative